Good morning, everyone. How's everybody doing today? So we are all set. Just waiting for things to happen. "13 people so far. Good morning, everyone, for showing up. I appreciate it. Looks like she got rid of her purple hair, which I think is a good thing. I think she should have done that before trial, though. Just my personal opinion. So guys, it's all set for sentencing. It's actually a pretty full courtroom. Well, I wish I could give you guys some blistering insight, but we're kind of waiting just now. There's not a whole lot to do at this point. Oh, I need to take this real quick, guys. I'll be right back. Hello, this is Sean. Wow, that was like perfect timing on my part, getting that phone call done.
Got a couple of things on the docket this morning, so we're going to take care of a quick matter in State of Tennessee versus R.O. Packmeyer. Do we have the parties here on that? Mr. Kelly? Where are you, Mr. Kelly? Oh, here's Mr. Kelly. We have General Yarbrough.
You're on, he's in the vestibule.
Okay.
And this will just be for announcement.
All right.
It's always fun when this happens. You've got a case that was trying to get resolved, and it's a non...
Yes, sir, thank you. We were previously guilty to one count of DUI section. Ms. Packmeyer, based on the treatment that she's done, Your Honor, this is going to be a split sentence. It's going to be 25 days. Because the remainder of that sentence has already been taken care of. Your Honor wants her to report? Do you want to set a court date certain within the next 30 days for her to just appear?
We can do that, and that's usually the easiest way to do it. We'll just set it, let's see, this is the 13th. Mr. Kelly, do you have a preference within the next 30 days for a report day?
Yes, as close to the 30 days as possible.
Okay, why don't we set it for June the 10th? That's a Friday.
Thank you, Nicole.
Ms. Packmeyer, if you will report here at 9 o'clock, and you'll be on the docket. We'll call your name, and when your name is called, you can just step back in the back and get you processed.
And that should be it.
Okay, and you're going to meet with Ms. Christian?
Yes, ma'am.
Okay, all right. All right, we'll see you back here, Ms. Packmeyer, on June the 10th.
Thank you.
All right, thank you.
You know, it does suck for that lady because now the whole world knows she's got DUI, which, you know, that's a crappy part about when somebody's coming to film a trial or some proceeding, and you happen to go right before it. Your client's business gets aired.
But I don't see Mr.
So, yeah. So right now the court's just clearing up her normal docket, it sounds like.
At noon, so that leaves State of Tennessee versus RaDonda Vaught. We're here in that matter for a sentencing hearing. Is the state ready on that? Okay, is the defense ready, Mr. Triumph?
Yes, Your Honor. Good morning.
All right, good morning. Okay.
I can't believe she's not wearing something that covers her arms. That just does not look professional.
Okay, so this is case number 2019-A76, State of Tennessee versus RaDonda Vaught. We're here today for sentencing hearing. So the state, you may call your first witness or present your first item of proof. Oh, actually, before we begin, Mr. General Jackson, I do want to place one thing on the record. In the time since we were here for trial and up to this point, the court has received a number of items of correspondence, letters, voicemails related to this case. And I certainly understand and appreciate there's a lot of public interest in the case. We have collected those letters. My staff has collected them. Voicemails have been reduced to writing by the court reporter. Those materials have been placed in the court file. The court has not considered those. It would not be appropriate for the court to consider them. So we provided copies to counsel for both parties for whatever use they want to make of those in this proceeding. So, all right, go ahead, John.
Thank you, Your Honor. If not, can I just inquire of the court, they are part of the court record?
Yes, sir. They're part of the court file. They'll be contained with the court record, but it's just that it's not matters this court has to confine its consideration to the evidence presented at trial and in this sentencing hearing. So those they have been collected as part of the public record, and they are in a separate file, but part of the court file.
So they don't need to be marked as an exhibit to these proceedings to be part of the record in this case?
It's part of the court file, yes, sir. It's not. It hasn't been. They have not been introduced as an exhibit to this proceeding, and I'm not going to consider anything that's not properly introduced as an exhibit to this proceeding. Does that make sense? But it is in the court file because we received it in connection with this case.
My only concern is if there's any review of this matter, I wanted to make sure that it would be part of the record that would be transmitted to the court.
Why? It's not part of the exhibits.
Now, I don't believe it would be automatically transmitted unless you designate it if it's not made an exhibit to the proceeding.
And, Your Honor, I don't intend to get into any of the materials that you received, but I think to protect the record, I've got what purports to be copies of all of the information that the court has received. Could we make this an exhibit to this hearing, just so it is part of the record?
General?
I think the defendant would have to adopt them in some way to introduce them. I don't think it can just be put in carte blanche without any foundation or anything, so I think the court's consideration. We've read some case law about that, and a procedure would be to send them to present them, sort of included in the pre-sentence report, and the judge could or could not review them or peruse them as part of the ruling. Anything the defendant submits can be taken under advisement as part of your consideration. I just don't think them coming in carte blanche without any foundation or anything else would be appropriate. But I'll leave it up to you, Judge. I know you know which way or not to.
Well, I mean, I think that, I mean, that is a concern, just to introduce, because as I said, I've not reviewed them because it would not have been appropriate for me to review them at that time. I don't know who they're from. I don't know that there's been any foundation other than these are just materials that the court received just independently of this proceeding. So, if Mr. Trice, if you would like for it to be included and supplemented as part of the pre-sentence report, that I wouldn't have a problem with that.
Because I think the court has already really laid a foundation based on the comments that you made when you took the bench this morning. And again, I'm not going to be referring to them in any way. I just wanted to make sure the record is complete.
You just want it to be included within
Yes,
the
sure.
record for any review. I mean, I don't have a problem with that, and however we need to make that happen. I like the proposal from the state that it be included as a supplement to the pre-sentence report, since it hasn't come in as a matter of evidence either at trial or at this point in the sentencing hearing. And I know that Mr. Strike, you presented a number of provided to the court a number of letters in support as well, which would be part of this sentencing hearing, and the court has considered that. So,
I think we could start it off then by just addressing the state's first piece of proof, which would be the pre-sentence report.
all right. So why don't we do that?
Before we get into that, Your Honor, typically I do address any errors or any corrections or anything that the state would like to make, and I'd like to make
Okay.
just for clarification for court's attention. On page 8 of the pre-sentence report, below the employment information and the comments below that, I guess we're going to consider it 1, 2, the third paragraph under comments. The report was she lost the job at HCA TriStar when the license was revoked due to the current conviction. And as a point of clarification, the state would like to introduce the certified copy of the order from the nursing board that shows the conviction was in July of 2021. This conviction, of course, did not occur until March of this year, so that probably needs to be clarified for some reference that wasn't the reason she was let go. And also, she was terminated, the next line, she was terminated from Vanderbilt due to the current offense. I guess it could be due to the current facts or the facts of the situations, but again, she wasn't charged until March of 2019. So we would like to introduce the pre-sentence report for that, and then the copy of the certified order as a clarification.
Mr. Trice, any response to those corrections or
Your Honor,
changes?
those are accurate statements.
All right. The pre-sentence report will be corrected to that extent.
And I suppose we could, Mr. Strikes, could be wanting to make those letters that he has and give it to that pre-sentence report. We won't object, other than noting that some of the letters are duplicitous. They are the same format and content and basically the same verbiage and signed by multiple people, but you'll know what to do with that.
All right, so Mr. Strike, we will introduce, we will accept as part of the pre-sentence investigation report the letters as a supplementary report. So that will now be officially part of the record.
And Judge, one other housekeeping matter, I received over 160 letters and things that I put on a flash drive. These were the unsolicited ones, not the character letters, the 40 character letters that I filed with the court. Do we have that marked as well?
All right.
No, Your Honor.
Does the state, have you provided the state copies of
I
that?
can give them.
Okay, all right. Well, that will be, the investigation, pre-sentence investigation report will be supplemented with both of those items.
Thank you, Judge.
That'll be Exhibit 1 to this proceeding. State may call your first witness.
State calls Gary Murphy. Is it what's gone today? Okay, sorry, Your Honor, he's having vocal trouble. Call Michael Murphy.
Stand here, raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, so help you God?
And he's wearing all blue as well.
Could you say and spell your name for the record, please?
Michael Murphy, C-H-A-E-L-M-U-R-P-H-E-Y.
Just ask you to speak up, kind of project a little bit. Those microphones pick up just a little bit, or we can move it closer to yourself if you need to. So, Mr. Murphy, how are you related to the late Charlie Murphy?
That was my mother.
And how many siblings do you have?
One.
All right, and who was your sibling?
Gary.
Do you wish to tell the court how the loss of your mother and everything that has transpired since December 26th, 2017 has affected you and your family?
Yes, sir. It's really played a big toll on me. It's, I was at work when all this took place, and I didn't get to say bye to my mom. Didn't get to give her a hug or a kiss. And when they brought her back up, she had tubes run down in her throat and stuff. And, my dad suffers every day from this. He goes out to the graveyard once, anywhere from 3 to 4 times a week, and just sits out there and cries over it. Dad's 83 years old. And, it's hard to sit back and see him suffering and crying and stuff over all this.
How has this affected you with the loss of your mother?
It's affected me pretty good. It's, it's just every time you lay your head down to go to sleep, you see I see the tubes running in there and stuff, and it really bothers me. And, within the last month, I've really just started dealing with it.
And what are you doing to deal with it? Are you going to therapy, or are you just talking through it?
I've been going out there and spending a lot of time at the grave site talking and stuff. That's seemed to help out a whole lot.
Is there anything you wish to tell the judge about how you feel that Ms. Vaught should be sentenced by the court?
No, knowing my mom the way my mom was and stuff, she wouldn't want to see her pull no jail time. But, that's just was mom. Mom was a very forgiving person.
How about your father? Have you discussed it with him?
Yes, sir.
And what's your father's opinion?
Dad, you just have to understand Dad. He just says that he thinks that she should pull the max on it, the maximum sentence.
And is that because, how long were your father and mother married before she passed?
57 years.
And was there anybody to step in the role of your mother after she passed?
Well, my sister-in-law has stepped in, and she's took care of, taking care of the bills and making sure he gets his medicine and doing errands for him and stuff like that, going to the doctors with him and stuff.
But that's all I have.
Just a couple of questions. Good morning, Mr. Murphy.
Morning.
My name is Peter Schreins. I'm a Nashville lawyer representing RaDonda Vaught, and I'm so sorry for the loss.
This is interesting. I don't.
The family has been particularly gracious throughout this entire process. Do you remember in December of 2017 when your mom passed that a family representative spoke to the Tennessean
Yes, sir.
and was very gracious in the family's comments at that point in time?
Yes, sir.
Do you remember what was reported by the Tennessean about the feelings of your family back then?
No, sir, I sure don't.
It's sort of what you told the court early in your testimony today. Do you remember the family representative saying that mother would forgive the nurse alleged to be responsible for
Yes, sir.
death?
Yes, sir.
Was that an accurate statement?
Yes, sir.
And that your mother would be very upset knowing that this lady may spend some of her life in prison?
Yes, sir.
Thank you, Mr. Murphy.
Nothing further, Your Honor.
Okay, that was weird.
Rhonda Murphy?
I didn't know you could do that. In Tennessee, apparently you can cross-examine a victim impact statement. That's really weird. I know in Ohio that doesn't happen. In a lot of states it doesn't happen. I don't know what the hell that was. So that caught me off guard.
your name for the record, please.
RaDonda Murphy, RaDonda Murphey.
And how are you related to the late Chandra Murphy?
I'm her daughter-in-law.
And can you tell the court how the loss of Ms. Murphy has affected you and your family?
I'm with my father-in-law quite a bit. I try to take my mother-in-law's place and doing things for him, and just watching the hurt that everybody's gone through. It's like my father-in-law said, it would be a whole lot easier to be able to deal with this if it was natural. But with, to add on to what my brother-in-law said, I've talked in great lengths with my father-in-law about this whole situation. And he doesn't want to see RaDonda go away for jail for many years. He really doesn't want that. But he does feel like that her life was taken, and it's just hard for him to deal with it. And then I watch my husband suffer. I watch my brother-in-law suffer. And it does take a toll on you. It'll break you down if you're not careful. I've had to ask God for strength many days. And just the hurt that everybody's gone through. I mean, it's sad all the way around for everybody. I mean, not only my family, but hers also. It's just hard. I stop and I try to think to myself, and you try to find forgiveness. And you just wonder, like, how many mistakes do you have to make before it becomes a choice? And I can't seem to find the answer to that. But just the hurt that I watch my family go through is horrible. It's absolutely horrible. And I try to be strong for them, but at times it's hard.
And do you have children?
Yes, sir.
How many children do you have?
I have 2.
And how old were they when Charlie passed?
Oh, it was 4 years ago. 33 and 34, 34 and 32.
And you've also got grandchildren?
Yes, sir, I have 4. But she never got to see her last one.
I believe that's all I have.
Judge, I have no questions for Ms. Murphy.
Thank you.
Yes, Your Honor, State Hall, Chandra Murphy. You swear or affirm that the testimony you're about to give will be the truth, so help you God. Ms. Murphy, please state and spell your name for the record.
Chandra Murphy. CHANDRA MURPHEY.
Ms. Murphy, I know you testified at the trial, and you were present during the trial, and now it's your opportunity to tell the judge how the loss of your mother-in-law has impacted you.
Well, it's impacted me because it's played a big role on our family, my marriage. We just feel that my mother-in-law got lost in all this, that it wasn't really about her. We've been harassed by Channel 5 News, knocking on my door, taking pictures of my house, questioning stuff that
She needs to be stopped. There's nothing to do
signed
with sentencing.
Was it legit? And we've just been harassed. I haven't had peace, nor our families had peace in 4.5 years. And when you lose a loved one, all you want is closure. And We haven't had that. This has been ongoing for 4.5 years, and it's just been sickening to us.
How, you mentioned your husband, and who is your husband,
Michael Murphy.
who we just heard from? What about your children and your grandchildren?
Well, it's affected them too. My kids are kind of quiet and keep their emotions to themselves. But we would always get together and have Sunday dinners. We had holiday get-togethers, and the kids, grandkids were all involved in it. And we'd go yard selling with Grandma, shopping with her, and we just did so much together as a family, and it just ended in a split second for us. I mean, it's like I stated last time, we still got her Christmas presents in our attic wrapped. And it's very hurtful when we have to get up there and look at that. But we just want peace and closure.
As far as sentencing, what would you like to tell the judge about how you think the defendant should be sentenced?
Well, speaking on behalf of my father-in-law, you know, because we deal with him quite often, and he cries every day. We talk to him on the phone, he goes to talking about it, and it hurts us to see him hurt so bad, and he has stated that he wanted her to have the max. But on our behalf, we forgive her. We forgive her. Do we think she actually intentionally went in there and said, I'm going to kill Miss Charlene today? No, we don't. We forgive her. My mother-in-law would want her to be forgiven. And jail time is not an option to me for her.
Is there anything else that you'd all like to tell the court?
No, just in the past 4.5 years, our family's been waiting, and it'd been nice to have heard at least, I'm sorry, come out of her mouth, and it hasn't. But
Why
deep down,
would
we're sure she is sorry, but it would have been nice to at least hear I'm sorry, with all the media and stuff being said to them, and never once, you know, was it sympathized for, I'm sorry. You know?
Yeah, she's just gonna throw herself on her sword like that for you. Come on, lady. Come on.
Thank you. Those are my questions.
Yes, I'm sorry she didn't just plea out and throw herself in prison right
Good
away.
morning, Ms. Murphy.
Good morning.
I think you appeared as.
I hate that
a witness in
nonsense.
the trial of the case, is that right?
Yes, sir.
And since you were a witness, you were not able to be in the courtroom when the evidence was being presented, is that right?
Yes, sir.
Were you ever able to hear the 2-hour or so interview that RaDonda Vaught had given to Special Agent Ramona Smith with the TBI?
I've heard bits and pieces, not the whole thing.
In the bits and pieces that you heard, did you hear RaDonda Vaught being very emotional and regretful and remorseful for her mistake?
I heard bits and pieces of it, but her talking to the TBI has nothing with standing on the media in front of the News Channel 5 and not saying it to the public and everybody for an apology to the family.
I understand. Thank you.
Thanks.
I can't stand that. Why didn't she just admit she's sorry? Because she's standing trial. She can't talk. You know, she has a right to remain silent. I want to hold that against her. I feel like those statements should be stricken. I've always thought those statements should be stricken from a record at a sentencing. Because she has a constitutional right, and that can't be used to punish her. Exactly, Shaw.
Will you please state and spell your name for the record?
My name is Ramona Smith, Ramonasmith.
And Agent Smith, you are the TBI agent who investigated the particular case that we're here on for sentencing, is that accurate?
Yes, ma'am, I did.
And you testified in this trial previously. Now, this court has heard all of the testimony since Your Honor presided over the proceedings. So I want to specifically talk about a separate incident with respect to Ms. Vaught. So I want to direct your attention to August of 2020. Do you recall an incident that you were notified about involving the defendant today, RaDonda Vaught?
Yes, ma'am, I do.
Okay. And can you tell the court a little bit about how you became involved with that?
Our general counsel contacted me, Jean Broadwell contacted me regarding a matter to see if RaDonda Vaught was still under indictment or if that situation had been resolved. And I asked her why, and she said that there was an attempt to purchase firearms at a local store in Gallatin, and they had to deny it, but they had to confirm that she was still under indictment.
No, let me stop you for just a moment. Do you recall when Ms. Vaught was indicted in this particular case, 2019 A76?
February
February of?
2019. I believe it was like January, February, I don't remember the exact date. She was arrested on February 4th.
Now, based upon the information that you were provided, were you actually assigned by the Tennessee Bureau of Investigation to investigate this particular incident?
I was.
Okay. And can you tell the court a little bit about how your investigation proceeded?
Based on the information I was provided, I went to the gun store in Gallatin and reached out to the individual, spoke with the individual, Nathan Gregory, who conducted the business with Ms. Vaught that day when she came into the store. In talking with him, she had come in and filled out the federal form, which is required for purchasing any firearms, any type of equipment, any type of pieces. He showed me the form where she had filled it out and signed it, and that she was denied, and he submitted her denial form. And then
Let me stop you if I can right there. What is submitted a denial form mean?
so when you go in to purchase a gun or any type of part for a gun, you have a background check done through the Tennessee Insta-Check system, which is the Tennessee Bureau of Investigation. We manage that. Goes through the system, and they check you for a background of criminal histories, indictments, things along those lines. And the TBI then sends a denial if there's anything they find as part of that background that would prevent them from purchasing a firearm. They then send the denial form back to the store. He does not know why it's denied. All he knows is that it's been denied.
Now, is there a way to appeal that denial?
There is, and he informed her of the denial. And it's almost instantaneous. That's why it's called Tennessee Instant Check, because it's done quickly. And so he told her it was denied, so she filled out a denial form, appeal form, and that is sent back to the Bureau. And then that takes a little more time, because then they have to go through the process of reviewing it.
Okay. Now, do you happen to have a copy of the firearms transaction record that Ms. RaDonda Vaught filled out that particular day in August?
I do. I left it in my seat, but I do have a copy of it, yes.
May I approach, Your Honor?
Thank you.
Agent Smith, I want to direct your attention to number 11 on page 1 of 6. If you look at section A, lowercase a, can you read that line?
The entire thing, or just the first part?
Just the first part.
Are you the actual transferee buyer of the firearm listed on the form?
And what did Ms. Vaught check?
Yes.
Now, let me direct your attention to section B, right underneath. Could you please read that line?
Are you under indictment or information in any court for a felony or any other crimes for which the judge could imprison you for more than 1 year?
And what did Ms. Vaught check there?
No.
Now, I want to direct your attention to page 2 at the very top. And if you could go down to maybe the middle of the paragraph where it says, I also understand that making, and if you could read that line.
I also understand that making any false oral or written statement or exhibiting any false or misrepresented identification with respect to this transaction is a crime punishable as a felony under federal law and may also violate state or local laws.
Now, Agent Smith, Could you tell the court who signed that document and what the date?
RaDonda Vaught on May 27th, or May 27th, no, I apologize, August 27th of 2020.
Your Honor, if we can make this State's Exhibit number 2.
And it is Exhibit 2.
I think they're trying to argue she's breaking the law and not following rules.
Investigation into this particular matter, was Ms. Vaught charged?
Yes, she was.
May I approach, Your Honor?
You may.
Ooh, she was charged?
Agent Smith, do you recognize that document?
I do.
Okay, what is that?
It's an affidavit of complaint for taking out a warrant for the arrest of an individual.
Okay, and what warrant? Whose name is listed on that warrant?
RaDonda Vaught,
Okay, and in what county was that? warrant?
Sumner.
Okay, and what was Ms. Vaught charged with at that time?
She was charged. Let me read through here. I'm sorry, hold on just a second.
Read faster, woman. Let's go. How did you not prepare ahead of time for this? Come on. Let's go.
Perjury, I apologize. A perjury of TCA 3916-702.
Perjury on a federal...
I believe it is a certified copy. If we can admit that as the state's next exhibit.
A state charge of perjury for lying on a federal form. I don't see how that works.
Upon following up, did you have the opportunity to speak with the owner of the Blue Line gun store? Okay.
Yes.
And what did he tell you about his interaction with Ms. Vaught that day?
Well, she came in, filled out the form, did the appeal, and then left. And then later that afternoon, she called in and said to him, "Oh, I think I have this court thing going on in Davidson County. That may be why they declined it, or they denied it."
This court thing?
Yes, ma'am.
Now, Agent Smith, were you present in the courtroom during the testimony of Sean Murphy? Today?
Today, yes.
And did you hear Mr. Stryan ask Ms. Murphy a question about Ms. Vaught being remorseful in her interview with you?
I did.
Okay. And I want to ask you, since you were the agent that conducted the interview, what is your interpretation of the way Ms. Vaught was acting when she did become upset?
In the course of an interview with an individual, you develop rapport with that individual. It means you have to empathize with them at times in their situation and what they've done, and help them to understand that to get that off your chest is soul saving, if you will. And she was very forthcoming, but she didn't seem shook by it until she found out that they were both from Bethpage. Her remorse during the case was of the attitude, in my opinion, as an investigator, that
Objection.
she felt
Object.
telling the truth
Object.
would all go away, and that she should be rewarded for being honest.
She
And I
should.
appreciate honesty. Honesty is an amazing thing. I don't find a lot of it. In
We
my time.
appreciate honesty. We still burned her down.
But it
This is
doesn't take away
nonsense.
accountability. And I don't think that she
What
feels
the
she should be
fuck are they
accountable. She
doing
feels
here?
someone else should be accountable.
This is a sentencing, not a
She was remorseful more from the
evidentiary
fact that
hearing.
She knew this was going to go badly in the criminal aspect, in the sense that it wasn't just administrative anymore. It became a criminal issue. And anytime anyone is charged with a criminal issue, they do tend to panic internally. That's just what they do, because they know there's potential
Does she need to be
fail.
stopped? This is
Once the
nonsense.
freedom's taken away.
This is not for a sentencing hearing.
I want to direct your attention. Were you
This is a
present every day?
frickin' lynching.
Most of the time when you could be in the courtroom for the trial in this
Yeah.
matter?
This was years and years later. This is not.
And
No
were
wonder
you
she's not
present,
like shook up.
After final arguments in this case?
I was.
Your Honor, at this time, we would like to play a snippet of an interview, and then I I'll certainly ask agents.
Oh my God.
Who is identified within that.
Why are they even mentioning the closing arguments? That should not be referred to.
District attorney's actions, the assistant DAs that are prosecuting this case.
Agent Smith, do you know who is giving an interview in this case?
That is Ms. Vaught.
Okay, and you see Ms. Vaught in the courtroom today?
I do.
I do agree she shouldn't have given a statement after the trial.
It's very obvious by the district attorney's actions, the assistant DAs that are prosecuting this case, all three of them in their lives. It is very obvious. They don't know shit about healthcare. They don't give a fuck about nurses. I don't care what Chad Jackson says.
Agent Smith, do you recall when this interview took place, at what point in time during the trial proceedings?
Yes, ma'am, it was between closing arguments and the verdict.
No further questions, please. Your Honor, if we could introduce this particular snippet.
Now, I will say they can introduce that statement at sentencing, the interview. This could be done. That's actually 100% kosher. But to do all this crap where you have witnesses coming on and cross-examination, no. This is insane.
I'd like to talk about the blue line guns.
This is why you shut the fuck up, guys. Do not talk.
The FBI was the lead investigator.
Do not talk.
Charlie Murphy case, is that right?
Yes, sir.
And I think you arrested RaDonda Vaught on the indictment, on the arrest warrant that was issued as a result of the indictment on February the 4th of 2019. Is that right?
Yes, sir.
And I believe the event at the Blue Line Gun Store happened on August the 20th of 2020. Is that right?
It was August 27th of 2020, yes, sir.
And then about a year later, August 18th of 2021, is when the General Sessions warrant was issued in Sumner County. Is that right?
Yes, sir.
One of your colleagues went up to Sumner County and secured that arrest warrant. Is that right?
Yes, sir.
So there was an entire year between the event and a decision by TBI to seek charges in this case. Is that right? Or in the Sumner County case?
It takes time to develop and investigate a case, yes, sir.
Did you investigate the case, or did your colleague, Colleen Dean?
I investigated this case.
Okay. And you said that you interviewed a young man that worked at Blue Line Gun Store. Is that right?
Yes, sir.
Was that Randy Gregory?
Nathan Gregory.
Nathan Gregory.
Yes, sir.
And I think you were asked a question about interviewing the owner of the gun store. You didn't really interview the owner, you interviewed Nathan Gregory, is that right?
I interviewed Nathan Gregory. I did discuss it with the owner who was there. He's Nathan Gregory's father.
And I'm sure the owner told you it's a father-son ownership of that gun store, is that right?
Yes, sir.
And I'm sure he shared with you that RaDonda Vaught and her husband were regular customers at the gun store, is that right?
Yes, sir.
And I think they had at least a 3-year relationship when this came up.
I don't know that. No, sir.
When you interviewed Nathan Gregory, did he tell you that it was pretty common for that incident check to come back denied?
I don't know about common. I know it does happen, yes.
And
I've been denied
told
before.
you, consistent with your testimony, that later that same day, maybe within hours of the event,
110 viewers. Thank you so much, guys.
I think I know why that may have happened.
Please crush that like button if you like this.
Now, do you have State's Exhibit number 2 in front of you?
No, sir, I do not.
Could she be here? That is the Bureau of Alcohol, Tobacco, and Firearms, a federal agency's firearm transaction record. Is that right?
Yes, sir.
And these alleged false statements on a ATF 4473 form are typically investigated by the Bureau of Alcohol, Tobacco, and Firearms.
Typically, they have to be. It's a federal
We're in
crime.
conjunction with them, yes, sir.
And how many of these ATF 4473 cases have you personally investigated before this one?
This was my first.
Now, you were shown State's Exhibit 2, and
No lies detected.
according to the Sumner County affidavit in support of the warrant, you're focused on question B, is that right?
Yes, sir.
And I think it's 11B for the record, is that right?
Yes, sir.
And let me read this, and you tell me if I'm reading it correctly. Are you, and the you would be the person who's seeking eligibility to purchase a firearm, is that right?
Correct.
Are you under indictment or information in any court for a felony or any other crime for which the judge could imprison you for more than 1 year? Is that
That
right?
is exactly what it said, yes, sir.
And it was TBI's insistence that there was a willful false statement made in this application that was presented to the court. Is that right?
It's very straightforward. It's 2 boxes, yes or no, and she marked no.
And I think it's fair to say this case has been pending a long time. Is that right?
It's been active a long time, yes, sir.
And there were obviously some discussions along the way as to whether this case could be settled in some way. Is that a fair characterization?
Objection.
There were several discussions along the way.
Objection.
And I'm sure that the district attorney's office kept you aware of those discussions.
Very much so, yes.
Yeah,
And
and
there
just
were
all
even
be careful
discussions
about it.
whether it could be settled maybe on a probationary sentence. Is that right?
I'm going to object to some questioning. I don't
Yeah.
think that that's pertinent to these proceedings or even to the trial proceedings about any settlement measures.
Overrode.
I'm not trying to get into the settlement, I'm just trying to focus on which the judge could imprison you for more than 1 year. That's one of the elements of the question that's put to the purchaser, the prospective purchaser of a firearm. Is that right?
It is one of the elements of the question. However, another element of that question states very clearly, are you under indictment or information in any court for a felony? And she was very well aware she was under indictment and been arrested for 2 felonies.
And then in the disjunctive it says, or any other crime for which the judge could imprison you for more than 1 year. Is that right?
By felony, the definition is more than 1 year in prison.
Well, you know that, and I know that, and the judge knows that, and the prosecution knows that.
But anyone that is being charged with crime and has met with an attorney such as yourself is very well aware of what a felony is about and how long they could be sentenced to court, or to prison. It's very well aware and it's commonly discussed between a defense attorney and their
And
client.
lay people still screw up.
Now, this was said before Judge Michael
Almost ask her,
Carter
how do you know I talked to her about it?
Sumner County General Sessions Court on May 4th of this year, is that right?
Yes, sir.
And Ms. Vaught and I were there in court, we didn't see you there that day.
May 4th, I was not there ahead of their obligations, yes, sir.
So, did you have an opportunity to talk to District Attorney General Ray Whitley or the assistant that was covering the case that day?
I have
Christopher
spoken
Boyano?
with General Boyano, yes, sir.
And there was really no need for you to come to Sumner County that day, is that right?
There was no need for us to come to Sumner County because we weren't having any type of a hearing. Agents go to court cases whether they're required to or not if they are available to keep up to speed.
But I would like to think that Assistant District Attorney Christopher Boyano or the District Attorney Ray Whitley would have had the courtesy to tell you that they were not going to prosecute this case.
They would have if that was the case. But in the discussion I had with Mr. Boyano, that was not the discussion we
Did
had.
Mr. Boyano tell you that they were going to suggest to Judge Carter that the case be taken under advisement for some period of time and then be dismissed?
General Boyano stated they are going to take into consideration the sentencing today and then make a decision if that's the way they are going to proceed. There was no definitives in any of it.
In your mind, it was not definitive?
No, sir. And I clarified that with General Boyano yesterday.
He told you that it's not going to be taken under advisement and dismissed?
No, sir. He said it is going to be taken under advisement what the sentence is today, and it is a possibility that it will be monitored for a year and then dismissed. But it was not said flat out that that was what he was going to do. And as a general rule, prosecutors don't settle cases unless they reach out to the agent to make sure everyone's on the same page.
Which I think is
Well,
nonsense.
did you have a discussion with them before May the 4th?
I've spoken with him several times.
Because you didn't appear on May the 4th, but because there was nothing that was going to happen that day.
There was, like I said, I had other commitments that day.
You talked about your interview of RaDonda Vaught, and that's, so it's clear for the record, it's the interview that was played to the trial jury in this case, is that right?
Yes, sir.
And by my recollection, it was about 2 hours or so.
It was.
And it was a very emotional interview for RaDonda Vaught, was it not?
Depends on how you define very emotional. I didn't find she was very emotional. I could tell it was trying on her, but she was not what I would consider remorsefully.
But you will concede that she was extremely transparent in what she was telling you about the events of this medication error, will you not?
Yes.
In fact, she truthfully disclosed to you how distracted she was that day and other things that were going on that sort of deflected her attention from things that she should have been doing.
Oh, yes, she admitted that she was distracted multiple times over and over and over.
And frankly, those candid admissions to you really made out all the elements of the lesser included offense that the jury convicted her of. Is that right?
Candid admissions? What do you mean by that?
What she told you, what she honestly disclosed to you on that 2-hour recording, basically was criminally negligent homicide.
That's what the jury found, yes.
And you told the judge that one of your interview techniques is to make sure that you try to understand the subject and maybe even empathize with the subject. Is that right?
Yes, sir.
And do you remember at the conclusion of that interview that you were very empathetic with RaDonda Vaught?
I was very empathetic with her, and I appreciated her forthcoming, and I shared that with the Attorney Generals. But that doesn't circumvent the seriousness of the amount of errors that she did. We all deserve forgiveness.
In fact, you were so empathetic at the end, you were reassuring her, hey, we all make mistakes.
Right, we all make mistakes. I make mistakes. We all make mistakes. However, every day, today, simple mistakes don't cause the death of an innocent individual that was charged to their care.
Those are my questions.
That would say.
Elizabeth Kessinger. Judge, just so I can be sure, no one has invoked the rule today. Is that right?
That's right. Please stand and raise your right hand.
You swear or affirm that the testimony you're about to give will be the truth, so help you God.
Good morning, Nurse Kessinger.
Good morning.
If you could state your name for the court, please.
Elizabeth Kessinger.
And if you could, please keep your voice up. You've got a very soft voice and it's a good courtroom. If you could spell your last name for the court reporter.
Kessinger.
And Ms. Kessinger, how are you employed?
I'm a nurse at Vanderbilt.
And how long have you worked at Vanderbilt University Medical Center?
14 years in June.
And where have you worked? What part of the hospital?
The neuro ICU.
The neurological intensive care unit?
Yes, sir.
All 14 years you've been in that unit?
Yes, sir.
And do you know the defendant in this case, RaDonda Vaught?
I do.
And if you would, tell the judge how you came to know RaDonda.
I was a nurse there, obviously, when she was hired, and I was her preceptor after she was hired, and then her co-worker after that.
And just so it's clear for the record, it came up at the trial, what is a preceptor?
A preceptor is a nurse that onboards newcoming nurses and trains them in the care of our patient population, policies, procedures of the hospital and the unit in particular.
And did you serve in the role as a preceptor for RaDonda Vaught?
I did.
So you helped train her.
That's correct.
How much experience did she have when she came to the neuro IC unit?
I think she had 2 years, maybe a year or two of experience.
While you were training her, what sort of impression did you have of her ability to learn the new position at the neuro IC unit?
I think the main impression was how motivated she was. She would do a lot of work on her own as far as learning our patient population, the diagnoses, the treatments, and she was also very attentive with the patients, going in the room and spending not only time doing the care, but just spending quality time with them and reassuring them.
And I believe you worked with RaDonda between 2015 and 2017.
Yes.
Is that right?
Yes.
How would you describe RaDonda Vaught as a person?
I think she's generous and caring, funny, motivated as well. Even as a person outside of the hospital, she's very motivated and resilient.
In that 2 years that you got to observe her work in the neuro ICU unit, did she become in some ways a leader among the nurses on the 6th floor?
She did.
And in what way did she demonstrate that?
It was her patient care. I think that she always went above and beyond with the patients, and I have described her previously as a nurse's nurse, which means if one of us was sick, she would be our choice.
I think it's safe to say that in the neuro ICU unit, you have some very challenging patients. And describe for the record the type of patients that the neuro ICU nurses deal with on a daily basis.
It depends on which area you're working in. I think it was talked about previously that we have an ICU portion of the unit, and then we have a step-down portion as well. The ICU are very high acuity patients with lots of comorbidities typically.
And let me stop you right there. When you say high acuity patients, what does that mean?
That means that as far as their illness and injury, there are multiple things that are going wrong. It's not just their neurologic injury that affects other systems of the body. So if there is a neurologic injury, that can affect their airway. It can affect other systems in the body. So.
And you mentioned comorbidities. What are comorbidities?
They're illnesses that patients have in addition to the injury that brought them into the hospital, which can obviously complicate the picture.
Can you tell the court a little bit about the culture of the intensive care unit, particularly the neurological intensive care unit?
It's very fast-paced most days. There are just a lot of things going on at any given time. You're not just taking care of your patient. It's kind of a community. We help each other because some of the patients are so sick that it takes a team.
I want to direct your attention back to December 26th of 2017, the date that this error occurred with patient Charlie Murphy. Were you working that day?
I was not.
At the trial, it was established that RaDonda Vaught was functioning as the help-all nurse on the 6th floor of the neuro ICU unit. What is the help-all nurse?
The help-all nurse is typically more experienced staff, and it's a nurse that helps with bedside procedures with physicians, helps the nurses with anything they may need during the day. We also serve as a mentor to all of the nurses. So if there is a knowledge gap, if there is questions that need to be asked by less experienced nurses, they would typically go to the help hall for that.
How does the role of the help-all nurse compare with the bedside nurses that are in the neuro ICU?
The bedside nurses have an in-depth understanding of their patient. They know history, what brought them into the hospital, where they are in the course of their hospital stay, and what to expect for that shift and the shifts coming up. The help-all gets a snapshot of each patient at the beginning of the shift, We have 36 beds, and we will sit in on charge report, and you know the patient's name, their admitting diagnosis, and their acuity is basically what you know.
This may sound like a silly question, but the nurses in the ICU unit, do they have to deal with distractions as part of the job?
Yes, absolutely.
And tell the court a little bit about the typical day in the life of an ICU nurse in terms of the distractions they're trying to filter as they do their job.
Well, first of all, are you asking about the help ball or the bedside nurse?
Well, let's start with the help hall.
Okay. The help ball carries a phone that is connected to all of the nurses. And then that phone is also, listed in the computer, so physicians call them, other providers, case management, the charge nurse. And you carry that phone with you all the time and answer the phone when it rings, kind of no matter what's going on. And then we also carry a rapid response phone. We don't anymore. We did when RaDonda was working there. So if there is a rapid response called on one of our floors, we would respond to that as well.
And is the help hall nurse also cast in the role of training throughout his or her shift?
Yes, at times. We will have orientees with us as well.
And if you had an orientee with you as the help hall nurse, how does that factor into the calculus of distractions and things that have to be filtered?
Well, it can be a very big distraction because you're talking through everything that you're doing. And questions, because you're teaching, you're getting asked a lot of questions at the same time.
Have you had a chance to discuss this medication error and the consequences of it with RaDonda Vaught?
Yes, sir.
What can you tell the court about the effect that this has had on RaDonda?
I mean, I think for a significant period of time it broke her.
I'm sorry, can you say that again?
I think for a significant period of time it broke her. It broke her heart. And her heart is still broken in many ways. There's been talk that, you know, she is resilient and she has built a farm, but she still has a broken heart.
Has she expressed to you how she feels about Charlene Murphy and the loss that the Murphy family has endured?
She's devastated and has been ever since. And she has said that she'll never get over it, and she knows that the family has suffered a terrible loss, and she understands what led to that loss.
Thank you very much for the super chat.
We are going to be asking the court to consider alternative forms of punishment, specifically probation. If the judge saw fit to place RaDonda Vaught on probation, there would be numerous conditions that she would have to abide by. You've known RaDonda for how long at this point?
6 years?
Knowing her the way that you know her, do you think that she could abide by all the conditions of probation?
Yes, I do.
Those are my questions. Oh, Kelly. Stand and raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, so help you God?
That looks like couch upholstery. It also looked like a jumpsuit for a second.
Good morning, Ms. Kelly.
Good morning.
If you could state your name for the court, please.
Kelly.
And you're going to need to spell both your first and your last name.
First name Kelley. Last name Kelley.
And where do you live, Ms. Kelly?
I live in Andalusia, Alabama.
And do you know RaDonda Vaught?
I do.
And explain to Judge Smith how you know RaDonda.
RaDonda and I went to grade school together, so I have known RaDonda for many years, over 26 years.
And have you remained in contact with RaDonda over those 26 years?
Absolutely.
Now, obviously RaDonda was born in Andalusia, Alabama.
I don't know where she was born. I know she was raised.
She may have been born in the Panhandle, but lived in Andalusia.
Yeah. Yes,
And you all went to school together.
we did.
How would you describe your relationship with RaDonda?
RaDonda's like a sister to me, so very close, like family.
And I believe you have children, is that right?
I do. I have two children.
And does RaDonda have a relationship with your children?
Of course she does. She doesn't have children of her own, but she's like a little mom of mine.
Describe for Judge Smith the RaDonda Vaught that you have known over the past almost 30 years.
RaDonda and I have known each other for, I'm so sorry if I, we've known each other for many, many years, and I have seen just about every side of RaDonda that you could possibly know about a person. RaDonda is sweet, she's kind, she's loving, she's caring. She has got the sweetest soul. I call her sometimes whenever I just need a little bit of a pickup. She's always there with a kind word. I love her dearly, and I just appreciate her always being there for me.
There came a point in time when RaDonda told you that she wanted to be a nurse, is that right?
Yes.
What was your reaction when you heard that RaDonda wanted to be a nurse and wanted to go to nursing school?
RaDonda, she'll be great at whatever she does. So when she said that, there wasn't a doubt in my mind that she would be so caring and loving, and she would give her patients the best care like she would if it was her own family. I mean, she's just so giving, and she doesn't ask for anything in return. She's just a giving person, and I knew that she would treat her patients in that same manner.
And did she possess those caring and loving and giving traits even before she went to nursing school?
Oh, yes, she's been like that since we were little.
You're probably her closest friend, is that right?
We've always been really close. Yes.
And I assume she spoke to you after this event at the Vanderbilt University Medical Center in December of 2017.
She did.
And what effect has all of this had on RaDonda in your estimation?
If tears were words, there would be many. We cried together a lot over this. Sometimes less words are more. We don't have to talk a whole lot about it. I know how she feels. I know the person that she is inside, and so there's no question as to whether or not she's broken about everything that's happened. There's no question about that. I think I don't really have to talk to her in depth about every little thing that happened because I don't really know all of that. I do not have a nursing background, so I don't know all the health stuff. But personally, I know that she's dealt with this very hard.
You know that she's lost her nursing license
I do.
and will never practice as a nurse again. What kind of work is she doing now?
She owns a farm.
And do you know roughly how long she and her husband have owned that farm?
It's been 6 years, 7. I don't really know the exact date, but it's been a while.
You visited the farm before, is that right?
We have.
Big operating farm.
Thank
is
you.
that right?
Yes, we own a farm, and so we go and get tips, take the children out.
And that is her life now, is that
It
correct?
is.
You've heard me ask another witness about probation and whether that witness or you believes that RaDonda could abide by the conditions of probation. Knowing her the way that you know her, do you think that she can do that?
without a doubt.
Do you think that she's got the mental discipline to follow any instructions of a probation officer or the court?
Yes, I do. She'll be on farm.
Thank you.
No questions, Your Honor.
Call Becker Ray. Stand here ready to bring in.
Do you swear or affirm that the testimony you're about to give will be the truth, so help you God?
I do.
Thank you, everybody, for coming in. 126 people watching. Yeah, this is just a weird way of doing a sentencing hearing.
Morning.
State your name for the court, please.
It's Rebecca Ray, R-A-Y.
Thank you. And where do you live?
I live in Bethpage, Tennessee,
And how long have you lived in Bethpage?
since 2018.
And what brought you to Bethpage, Tennessee in 2018?
I'm not really sure what brought me to Bethpage, but I think I know now.
And when you moved to Bethpage, did you come to meet a person named RaDonda Vaught?
I did.
And explain to the judge how you came to meet RaDonda.
My husband and I were walking my granddaughter along the road, Old Mount Vernon Road, and her husband and her pulled up and said, "It's pretty dangerous to walk a baby on this road within a stroller," and they were concerned, and then they introduced themselves, and we both talked about. I was a nurse practitioner, and I explained a little bit about myself, and she told me a little bit about herself, and then we just hit it off from there.
And you all became friends.
We did, yes.
And how close do you live to RaDonda's house?
Just a couple miles, but we live in a big farm community, so that's like next door.
How would you characterize your relationship with RaDonda?
RaDonda and I have really bonded over the last few years. I'm a nurse practitioner, and so my first year as a nurse was in the neuro ICU. I was also in labor and delivery, and I had a lot of different positions as a nurse, so we tended to tell a lot of just stories, just bonded over patient stories, and I really realized that she was the kind of nurse I was. She's the kind of person that I would want to take care of me. I'd want her to take care of my family. She just embodies the soul and strength and resilience of a nurse, and I just admire that in her so much, and I just have been so blessed to have her in my life.
I think you were here for every day of the trial, is that right?
I was.
You and your husband were here in support of RaDonda, is that correct?
Yes, we were.
Thank you, Melinda.
What sort of qualities have you seen in RaDonda over the past few years that you've come to know her?
She is one of the most generous, loving, honest, caring people that I have ever known. And I mean, I don't have a lot of close people in my life, but I consider her one of the closest. I can tell her anything, even through all of this that's happened. Anything that's happening in my life, she's a listening ear. She's, anything, and so she's very special to me and to my family as well.
I think now she's exclusively on her farm, is that right?
That's correct.
You've heard the questions about probation. Do you think that she could abide by conditions of probation?
Absolutely, yes. I think she is an excellent candidate for probation.
Thank you.
Thank you.
No, you're not.
No, this is more about
Caitlin's strokes.
It's not necessarily character witness. This is about whether or not she's going to comply with the rules of probation. This is being done in a hearing context, which is weird, but whether or not she'll follow the rules, whether or not she follows laws.
Good morning, Ms. Stokes.
Good morning.
If you could state your name for the court, please.
Caitlin Stokes,
And if you could spell your first name for the court report.
Kaitlyn.
And where do you live now?
I live in Bowling Green, Kentucky.
And how are you currently employed?
I'm a nurse practitioner with Commonwealth Health Corporation in Bowling Green, Kentucky.
And you know RaDonda Vaught?
Yes.
And explain to Judge Smith how you know RaDonda.
I went to nursing school with RaDonda, so we met in 2012. We became essentially nursing school wives, is what we like to call it, because we were best friends throughout nursing school, finished together. We both worked together at VUMC, and we've remained friends since then, and she is my daughter's godmother now.
What were your observations after you all graduated and got to see RaDonda function as a nurse? What were your observations of her competency as a nurse?
I always like to tell people that RaDonda is a better nurse than I'll ever be, that she is the kind of nurse that I wish I was, because she's the kind that she takes the time with her patients to sit and explain to them things that no one else has. She will paint their nails, she will trim their toenails, she cares about the human experience genuinely and takes the time and effort to show that. She is thorough, she is competent, she is caring, she is, as others have stated, everything that you would want in a nurse.
In terms of her devotion to her patients during the shift, did that ever interfere with her ability to get her charting done within the normal hours?
Yes, she would often stay late. We would call each other and talk to each other at the end of shifts, and she was always over her shift times because she would spend so much time in her patients' rooms that she didn't get the time to sit at the computer where others, may get in, do a task, get out, get to where they can do their charting. She would take so much time to explain things and take so much time to do the right thing that she did not get to do her charting until
Welcome in, Liz.
Thank you.
And you told the court about the extra effort that she put
Behind.
forth with her patients. Do you have any specific
So I haven't seen
recollections about
pretty much any of it.
instances that struck
Oh.
you as being
It's very weird. It's done almost like an evidentiary hearing, where you can cross-examine the people testifying.
Sustained a head trauma. She was 16.
That doesn't
and
seem
she
normal.
was set to go to a rehab facility. She's been
It
in
might be
the
for Tennessee.
neuro ICU for an
Oh,
unknown
okay.
amount of time that I'm not aware of, but I know it had been a few days, and in the dynamic, changing atmosphere such as an ICU setting, you don't
This is one of
often
her
have
friends.
time to do the little things like take out the particles of debris from the trauma that occurred, or wipe blood. and
So they
things
haven't
like that.
sentenced her yet, I'm
She told me
assuming.
about how
No.
Okay.
this girl being 16,
she hasn't
wanted
even
her to feel
spoke
good.
yet.
She wanted her to have the best start that she could going to this rehab facility. And so she took the time to get the remainder of the particles of trauma, the glass, things like that, out of her hair. She wiped the blood. She washed her hair and braided it for her. In true RaDonda fashion, she said, look good, feel good. That she wanted
Thank
her
you, Shannon.
to feel good, even though she was in this compromised neurological state, to be able to have the best fresh start she could in a rehab facility.
And I don't want to get too personal with you, but did you have a difficult pregnancy and some health issues?
Yeah, this is her friend who's an NP.
Yes, so I was admitted to the hospital with some emergency complications when I was 8 months pregnant with my daughter. And I was in the hospital for 10 days. We knew that I was going to stay there until delivery. It had happened in the middle of the night, so I kind of came as I was, didn't have anything. And all I did was let RaDonda know. And the way that RaDonda works is that she is thorough, and she's your person that you want there. And all it took was one phone call, and she showed up with 2 giant bags of every, coloring books, a fire stick, shampoo, personal care essentials, pajamas. She brought my family food. We have a picture of her actually plucking my eyebrows and painting my nails in the hospital. And this is in the middle of when she is having her life crisis and when this is going on. And she said,
You know, we're not talking about that, we're here to care about you. And that's what RaDonda does, she cares. She cares.
As a friend and a colleague, did RaDonda talk to you about the Charlene Murphy incident at Vanderbilt University Medical Center?
She did. She called me the same day that it happened. Again, we would speak to each other usually daily on our commutes, and that day she called me.
Judge, I'm going to object to your side.
And I see some people in the chat saying that, you know, she made a mistake and she should have caught it, and she should. The issue here is that she did make a mistake. She owned up to it. But how do we punish nurses for making mistakes is the issue here.
Well, exactly. Yeah.
It's not usually criminal, and that's just going to make people not ever report a mistake ever again in their lives. So not that she didn't mess up. I think everybody admits that she really screwed up.
Yes.
Like, she admits that.
What did you discern?
Yes, everybody agrees it was a mess up.
Yeah.
On RaDonda?
Yeah. Essentially,
And she lost her nursing license, so like
She-
she's never gonna
spoke as though the best way
Yeah.
that I know to phrase it is
be able to do that again.
someone that had experienced a trauma, someone that was in a trauma response. She was slow to speak. She was questioning how this happened. She was very tearful. She was concerned for both Miss Murphy as well as what is to come as far as her job and, you know, where this would go. I reassured her at that point and told her about a medical error that I made, a medication error that I made, and the outcome of that, and how it was a large error, and how it had a positive impact and a change of culture in the facility, and reassured her that these things happen and that she did all the right things and she did everything she could.
And they do. And I think that's something that this case kind of blew wide open is like, there are tens of thousands of people who die every year from med errors. And the only way to make them not happen again is by reporting them okay, so we learn and more people don't suffer the same consequences.
Are medication errors pretty
But this is not like a one-off thing.
Yes, absolutely. I have had many medication errors, one of which was very large, and I'm just lucky that the patient outcome was a positive one. I know several people. I don't know anyone who has said to me, I've never made a medication error.
Correct.
Do all nurses report their medication errors?
No, they don't.
No.
Yeah.
Nurses are advised to report their medication errors. I mean, we know that it is the right thing to do. We are told, you know, that is how you change a culture, that is how you improve processes, and that is what the culture is. However, it's terrifying whenever you make a mistake like that and you have people's lives in your hands and things. You instantly have that flight or fight response, and you think, oh my gosh, what do I do? And of course, our job as nurses is to care for people, and so we check on the patients and then we report. But I'm sure that there's many nurses that do not do that, especially if there is fear of retribution.
Those are my questions.
You said that you had a very large medication error. Did that result in a patient death?
It did not.
Why did it not result in a patient death?
I caught it in time, essentially.
How did you catch it?
I went to do the same error twice. I actually had this error. It was with insulin. So insulin is a double check medication. You have to have it checked by another nurse. I actually had it checked by 2 nurses because something seemed off. Both nurses gave me the go-ahead. And so I administered the medication.
It's very common for people to double check but not even really look.
Patient ate.
Because you're so
Yeah.
busy that you're just like, give me your fingerprint, and they scan it and they don't ever really look at it. It happens all the time.
Yeah, they're basically making sure you're not giving them battery acid. And that's it.
Exactly.
In a TB syringe and not an insulin.
Which is sad because, I mean, the double checks are there for a reason, but you're so busy that a lot of times it just gets skipped over.
I mean, heck, that happens when a paralegal gives you a document to look at. Yeah, it looks good.
Yep.
Were you going to give the patient fast acting or slow acting or long acting?
I believe it was fast acting. I was in the ER, so sliding scale is not something that we do primarily. It was.
I hope she has been disciplined because this could open her up to liability.
But how did you realize there was?
I was gonna say, like,
She should be very
such-
careful.
yeah, I was gonna say,
Your
I have
anxiety-
situations running through my head where I've seen,
Yeah.
but I'm like, I'm not
Yes.
gonna talk about that on the internet right now.
Yeah. Your anxiety's going, like, is the state watching this one?
Yeah, she probably, and if she reported it, then, I mean, that happens all the time. Like, I
Sure.
have seen countless numbers of things where, with very different outcomes with insulin, especially.
Don't have, am I allowed to not comment on that?
I would object. That's illegal. That's a legal statement. She has no idea.
Yeah.
Can you repeat the question?
Would you,
Yeah.
since you're preparing
Thanks, Law and Lumber. Thank you, Rob.
would you lie on federal firearms?
Your channel's awesome.
which qualifies as a state and federal?
Not
Objection. Objection. That this is ridiculous. Yeah.
Like, yeah, why was she getting called for that? If anything, just be like a,
Well, not no. That was the
character.
the prosecutor gets to. You get to cross-examine the person offering a statement. So, apparently, after she was indicted, she went to go try to buy a gun and got denied, and they're claiming she intentionally was trying to break federal law by doing that.
Oh, so that's why they're doing all of this?
Well, they're bringing up the whole buying a gun thing. They're bringing
Yeah.
up everything. It's that part's standard in a sentencing hearing, but
Good morning.
If you would spell your last name for the board.
SHAFFER.
And you are a nurse, is that correct?
I am.
And how long have you been a nurse?
September of 1997.
And do you know RaDonda Vaught?
I do.
And please tell Judge Smith how you came to know RaDonda.
We met in February of 2019 when she came into my department as a new employee.
And how long did she work in your department?
She left in December of 2019 to go into a separate division.
And over the course of knowing RaDonda, did you all become friends?
We did.
And could you describe the type of person that you find RaDonda Vaught to be?
Yeah, she, she walked into our office not knowing, really what the job that she was going to do entailed. And we weren't sure because we hadn't met her before. And what we found was that she was a very quick learner. She was a great addition to our team. She was always willing and open to learn new things with a really cheerful attitude. In the middle of what had to have been a scary circumstance because it was a brand new type of job that she'd never done before.
Did there come a point in time that you and RaDonda talked about the medication error that she made while she was at
we're going to come
Yeah,
back
we
to
never
that
really,
one.
Talked great deals of specifics, but we talked a lot in generalizations about what had happened, yes.
And did you form any judgment about the effect that the entire incident had on RaDonda?
Oh, I know that it was very devastating for her. She always expressed regret in regretful tones whenever we were discussing what had happened. I know that the burden of what she had done weighed very heavily on her.
And I think, if my math is correct, you've been a nurse about 25 years at this point.
I have the gray hairs to show that, yes.
Do you have any thoughts about RaDonda's conduct immediately after she realized that she had made that medication error?
I know that she was very open and she was very transparent about what happened. No one had to come and ask her, what happened with your patient. She was the first person to say what she did. I think in an instant like that, it shows a great strength of character.
Oh my gosh,
to
yeah.
be able to say, this is a mistake that I made and I did this.
And to know the implications of it.
Which is, I just thought that was an important aspect of her character to know.
And most people don't do that.
Universal response of all nurses immediately
You know, I've never, I hate to say it's not universal, but nobody has ever come up to me and said, well, I did this and I didn't tell somebody immediately. But I do know as a human nature, when you make a large error, that it's not always the first thing you want to do is take responsibility for it. I think it's probably easier to talk about it in human nature terms.
We've been talking about a request that we're going to make with Judge Smith about probation. And you've been in the courtroom this morning. Do you also agree that RaDonda Vaught is the kind of person that could abide by the conditions of probation?
I don't have any concerns that she wouldn't be able to.
Thank you.
Yeah, she just wants to live on her farm. And with what they were saying there, I mean, I have seen many times people make very large errors and then try to cover them up.
Oh, I
Because
bet. I guarantee.
You panic. Yeah, you panic, like, understandably, because you know that, oh my gosh, this is going to not go well at all.
Yeah. I mean, you got kids, you got a house, that stuff alone.
And it's not, and you didn't do it on purpose. Like, that's why it's so.
Here we go.
I would like to apologize to this worthy speaker first of all, and I'm sorry that you haven't released her. I'm sorry that I haven't said it to you sooner. I'm so sorry for what you have lost and for what my actions have caused your mother, your wife, your grandmother. She did not deserve that. And I'm sorry that this very public outpouring for me has been something that has caused you all to continue to live this over and over. You don't deserve that. And I'm sorry. I hope that it does not come across as people forgetting about your loved one. When nurses are upset, they're upset because they want people to take care of people.
She's apologizing because the family is really upset that everyone has had such a public outcry against how she's being treated.
Yes.
If you can't hear in the chat, that's what's happening because the family was very upset and she's saying she's sorry.
Horribly, horribly sorry for what happened.
We're dealing with a conflict of
But I'm sorry that
nurses are trying to defend themselves and it's dragging this poor family through a terrible situation at the same time as a casualty of it.
ever forget.
Man, there's somebody's typing away hard. I can hear it.
I know.
I don't know what else to say that is going to make anything any different. Saying I'm sorry doesn't seem like enough, but you deserve to hear that, and you deserve to know that I'm very sorry for what happened. I wrote a statement, Judge Smith. Words alone will never fully express the remorse and the sorrow for my actions and the horrific loss of Charlie Murphy's life. I am forever and will be haunted by my role in her untimely passing. Numerous times a day I think about her. I have a picture of my grandmother at my house. Every time I see her, I think about Miss Murphy. Every time I see a Vanderbilt logo in Nashville around town, I think about her. I see a person wearing scrubs, and I think about her. I go to check my mail, and I think about her. People walk up to me on the street and offer hugs and condolences, and my first thought is, they're hugging me, but someone else is gone because of that.
I'm not sure if I'd have mentioned that part if I were her.
No. She is very much alive in my mind.
She should.
And will be. Every day she reminds me of the consequences of my actions. Helping others is a trait that's always come really naturally to me.
The volume's all the way up.
A lot of
joy and fulfillment in my life. And when I became a nurse, caring really genuinely for my patients and their families it was just an integral part of my daily life. When they would express gratitude for how I provided care for them, I would tell them I care for people like I would want my grandmother to be cared for. And on that day, I let her down. I let Charlie Murphy down. I let her family down. I let myself down. I was horrified and completely lost. As I said, there's no book on how you proceed. No one's going to tell you what to do after this, or how to feel, or how to express yourself. So, in my profession, you are trusted to be honest, and that was the only thing that I knew to do, was to just maintain my composure in what has been a really horrible situation, and try to do the only thing that I have been educated and trained to do in this aspect, which is to tell the truth. At her bedside, Ms. Murphy's bedside, to her providers, to my charge nurse, to the human educator who was present, to risk management, to my manager, to the associate nursing officer, to the Veritas report that I filled out there that day, giving as much detail as I could about what happened. 8 months later, I was interviewed by the Department of Health, and I spoke with her in Randolph and provided her with about a 2-hour account of what happened. Another instance, again, I had another phone call with an agent from the Department of Health, providing her with answers to what happened. In November, I spoke with another agent, and in December with Ramona Smith of the TBI in her office there at the Medicaid Fraud Division, and I have tried to just maintain a professional composure because I don't know what I'm supposed to do otherwise. So if my statements or lack of what appears to be emotion on the outside came across as unremorseful, I can only say that that was terribly inaccurate. In my life, I have learned to hold things in and deal with it. You keep your composure together until you are able to deal with that separately, and that transfers over into nursing and healthcare. You can't be the person to stand at someone's bedside in the middle of something really awful and chaotic happening and fall apart. You have to learn that your emotions and your shame and your remorse aside, and you deal with it. You don't put that on other people. You don't bring it into that situation. You deal with it at a later time. And the people that spoke to you today, I think that they expressed that I have dealt with those things privately. I tried my best not to bring those things into a professional description of what happened here. I just want to make that very clear. After the last interview with Ms. Smith and I was indicted on charges, I did obtain an attorney, and then again, I
even with Mr. Schneid's advice, I have continued to tell the truth and express every detail, both in retrospect of what happened, so that the information could be used in the best way possible to make changes, to make people aware of what happened and understand and evaluate this process within healthcare systems so that things like this don't have to happen again.
She is really throwing herself on the sword here. I'm very impressed. This takes a lot of integrity
Openness and honestness
and a
about
lot of humility.
It does.
my mistakes can help someone to evaluate how to change things for the future of healthcare.
And that's been one of the frustrating parts all along is like, she's never said she didn't mess up. She immediately said it. Like,
Well, I know, but even now she's talking about,
yeah,
she's like, I kept answering because I want to make sure this doesn't happen to anybody else.
yeah, yeah.
That's,
I make every attempt to acknowledge responsibility for my actions.
you usually don't hear that in a sentencing statement.
I have lost far more than just my nursing license and a career. I will never be the same person. When Miss Murphy died, a part of me died with her. And sadly, it was too late to change her outcome when I realized my mistake. But as a nurse, I can think of no other way to honor and respect her than to disclose every detail that led to her harrowing death in an effort to ensure that this might never happen to another patient. And I have replayed my mistakes over and over again. I have certainly fallen from grace. I have experienced anxiety, depression, remorse, sleepless nights. This has been the most horrifying experience of my life, and at the same time, the most humbling experience of my life. It is not an easy task for me to stand here in front of you and in front of this person's family, knowing the death that she suffered, and knowing the 4.5 years that they have suffered since this, and ask for your leniency. At the same time, I can't see any public benefit in a harsh sentence. I have no way of ever recommitting benefits like this. I do not have a nursing license, and I will never be able to practice in patient care again. I will never be able to reoffend. I'm not a threat to public safety. I am concerned for the people in healthcare and anyone who might be a patient in person, who might become a patient in the healthcare system, that this sentencing is bound to have an effect on how they proceed. Both in reporting medical errors, medication errors, raising concerns that they see something that they feel needs to be brought to someone's attention, and could potentially have a negative effect on them. And I worry that it's going to have a deep impact on patient safety. And that comes from the point of
and we want to make sure that we do things in a way that protects them. It's a very difficult situation to try to express how I feel and how this affects healthcare, and also what is appropriate in the justice system. They operate very differently. I'm just very sorry. I'm very sorry for what happened. Please, within your consideration, I humbly ask you to consider the appropriate sentence.
Yeah, that's our proof.
That was amazing on her part. That was a very good job.
Yeah, that was. Pretty much everything she needed to say.
Responsibility is to determine the length, manner of sentence. First of all, the state would like to point out that we do believe there is an enhancement factor that applies to this factual scenario. And that enhancement factor would be the defendant abused a position of public or private trust. And quoting from the opinion of State v. Kissinger, 922 Southwest 2D 482, 1996. Factor 15 allows a sentence to be enhanced when the defendant abuses a position of public or private trust. As such, application of this factor requires a finding first that the defendant occupied a position of trust, either public or private.
How do you negligently abuse a position of trust?
Yeah, like.
There's no men's. You can't accidentally abuse authority.
Thus, the court should look to see whether the offender
That's the nature of the job.
stood in a relationship to the victim.
I mean, you have to intentionally abuse authority.
Yeah. If she was manipulating their trust, okay.
Your Honor, I
Like,
submit to you, the victim in this case, Charlie Murphy, was a patient at Vanderbilt Medical Center.
Okay.
RaDonda Vaught, the defendant in this case, was asked to administer this medication. She became the target.
and she made a mistake.
She therefore began a relationship with this patient.
Okay.
A practitioner-patient relationship.
I agree so far.
Yep, yep.
Enhancement factors and all. The language of the factor that the defendant abused a position of public or private trust suggests to me that there is some sort of intentional or deliberate
There we go.
mental state that would be required for that factor to apply. Are there any cases in which this factor has been applied where the mental state of the offense is more of a criminally negligent or something, where there's been a mistake of this nature? Obviously, we don't have cases just like this.
Right, Your Honor, and specifically, I think in this, and I'll go down a little bit further, and let me just finish this portion.
Please don't.
If the evidence supports that finding, that there was a relationship, and that relationship promoted confidence, reliability, and faith, I don't think there's any question as to this patient-practitioner relationship based upon the victim, and she relied upon a practitioner, a nurse, to get
So in
her
that
the
case,
best
literally
care.
any healthcare
Then it says that
mistake
if
ever.
the evidence supports that finding,
Under this theory,
then the
anything
court
is an
must determine
abuse.
whether
Yeah,
the position
yeah.
I mean,
occupied
not
was
even in
abused by the
for
commission of the offense.
medical, but
And
anything.
possibly
Yeah.
this particular enhancement factor may apply more to the gross neglect of the patient, where.
So can't you believe it is applicable to count one?
More specifically, Your
I have
Honor,
seen
Your Honor makes a
healthcare
good point
providers
on that, but
abuse
the
trust in a
application
patient
of that intent
to
would
harm
be
the
knowing
patient. And this
standard,
is so
and she
not
made a
that,
knowing
like,
choice to
so
walk
not
away
that.
from the patient, knowing
That
that
would-
she had
yeah.
to provide that care and monitor that patient. And so I think based upon the analysis by this court, the court must determine whether that position occupied was abused by commission of the offense. And I think it's very clear that when she made that knowing choice not to stay with that patient and not to monitor that patient, that she abused her position.
These are the case against Kissinger.
Yes, Your Honor.
Real quick, big thank you to Corn Pop for going and spreading the word. I so much appreciate that. Thank you so much, Corn Pop.
And that particular language is on page 8 of the opinion. Your Honor, I'd like to jump over, I know Mr. Stryans submitted a sentencing memorandum to the court, and having one day, we submitted a brief response to that memorandum. But I think what is very important to note, Mr. Stryans talks about the ability of the defendant to receive 4035-313, judicial diversion. And specifically within the 4035-313 statute, now, the conviction in this case, as it pertains to count 1, impaired adult abuse or gross neglect of an impaired adult, 71, 6, 117, and 119 were applicable back in that time. And that would have been under the welfare code. Specifically in looking at 4035-313, the effective dates of July 1 of 2017 to July 30th of 2018. As used in this subsection, a qualified defendant means a defendant who, jumping down to subsection C, is not seeking deferral of further proceedings for a sexual offense, a violation of 3915-502, which is exploitation of a vulnerable elder adult, 71-6-117, which would be abuse or neglect, or 71-6-119, gross neglect.
This should be in motion
This
practice
was the
beforehand.
conviction of the charge that the defendant was found guilty of. This particular conviction is
We'll have to talk about
precluded
what that means later because
from
I don't know
any
those words.
Deferral under
Sure.
4035-313.
They should have filed a motion before the
Furthermore,
hearing saying what
looking at
she should
the
get.
statute from effective from July 1st, 2017 to December 31st of 2018, specific knowing abuse, neglect, or exploitation, TCA 71-6-117, it also encompasses 71-6-119, which would be the higher charge of gross neglect. Following a conviction for a violation of this section, or section 71-6-119, as was the verdict in this case, the clerk of the court shall notify the Department of Health of the conviction by sending a copy of the judgment in the manner set forth in TCA 6811-1003 for inclusion pursuant to Title 68, Chapter 11, Part 10. Upon receipt of the judgment of conviction, the department shall place the person or persons convicted on the registry of persons who have abused, neglected, or misappropriated the property of a vulnerable adult. So, meaning, upon conviction for 71-6-119, the defendant automatically is permanently placed on the Tennessee Adult Abuse Registry. In addition to any other punishment that may be imposed for a violation of this section, if it's determined by the court the victim was 60 years of age or older, then the court shall impose a fine in an amount between $50 and $200. The additional fine shall be paid to the clerk of court imposing the sentence, who shall transfer it to the state treasurer, who shall credit the fine to the general fund. So, Your Honor, those are conditions that are placed upon the defendant's sentence specific to a conviction for 71-6-119, also precluding her from obtaining 4035-313 as to count 1. Furthermore, Your Honor, technically the defendant could be eligible for 4035-313 judicial diversion as it pertains to count 2, criminally negligent homicide. I'm reading from an unreported case, State versus Profit, that also cites a reported case, State versus Cutshall, 967 Southwest 2D 332. In determining whether the court should grant judicial diversion, the court could also take into the same factors as pretrial diversion. And it goes through a list, several I think are very important to this case. The court should consider the defendant's criminal record, social history, mental and physical condition, attitude, behavior since arrest, emotional stability, past employment, home environment, marital stability, family responsibility, general reputation, and amenability to correction. Talking a little bit about attitude, this court heard the recording that was played in the state's proof, a snippet of an interview that was given by Ms. Vaught in this case where she uses curse language to a reporter about the actions of the district attorney generals in prosecuting this case. And certainly this court is well aware that we have a job, we are assigned to do our job. It's nothing personal.
It sounds personal.
A case as with any case
Yeah.
in Davidson County. So I think the court should take that into consideration.
Aren't the factors that the court considers on judicial diversion sound?
You have offended me personally,
Yes, Your Honor, but these factors
so
are
you should
also
definitely be
laid out
sentenced
in more
worse.
detail here in State versus Cutshall.
Sounds like what she's saying.
Yes,
mentioned
even
in
the
State
judge
versus
isn't buying it,
Vaught.
they'll listen to the
This particular
pushback.
case
I
deals
know.
with
I'm really
a
glad that
nurse
this
who
judge seems
committed
very
willful
fair.
exploitation, neglect, or abuse.
Electroplating doesn't mention attitude.
Your Honor, I think this is a more detailed list. Certainly it says, and I'll read from the top of that, once a defendant is deemed eligible for judicial diversion, the trial court must consider several factors when deciding whether to grant judicial diversion.
I wonder if the judge read any of the letters that I know she must have received.
She did not.
Didn't she?
Normally
Do they normally or no?
No, because those are out-of-court communications by independent parties that nobody's privileged to, so that's all ex parte.
See, that's a good thing to know because we all rallied together and wrote thousands of letters
Well,
that are just sitting there.
they can be used to show volume of support.
Oh, okay. This is why I need LawTube, because we don't know what we're doing.
In this particular case, behavior since arrest. The defendant picked up a new criminal charge, has engaged in criminal conduct.
She has not been charged yet, I understand.
Specifically providing false information on a federal form in the court.
How is that a state level?
To review.
That is not a state level offense, though.
It's obvious that the defendant did not provide correct information and therefore was charged.
She doesn't have the jurisdiction to charge that crime.
Certainly, the defendant's lack of criminal
Don't tell her
record
that because she seems to really think she
play
does.
in her favor here.
Yeah. When you lie in those forms, it's a federal crime, not a state crime.
From members of the community who have come and testified for her. And I think the court has a balancing test there. But I think the state's position here would be that the court do take into consideration Ms. Vaught's actions prior to sentencing by this court. Her actions in the media as well as her actions in committing other crimes. I do believe Mr. Jackson would like to give a brief response following Mr. Cheyenne.
Let me ask you before you sit down, John. Because I didn't hear you address the application of an enhancement factor and the question of diversion, but talk to me a little bit about whether Ms. Vaught is a favorable candidate for probation.
Your Honor, based upon the law, being convicted of a Class C felony, being convicted of a Class B felony, she does pose to be a favorable candidate to probation. Of course, the court obviously takes into a balancing test there based upon her actions, whether she appreciates the nature of this charge, of this conviction. So the court has a balancing test as well based upon her conduct to make that determination. But as far as the law is concerned,
So she is statutorily eligible, having been convicted of a Class C and a Class E felony, there being no evidence to the contrary. Does the state see any evidence to the contrary that would make her an unfavorable candidate for probation?
The state's position, as Your Honor can see, is we don't believe that, well, obviously, she's precluded from diversion as to count one.
To me, it seems like they're being really nitpicky. Does it seem? Okay.
No, I mean, if they really don't want you to get something, they will.
With respect to the diversion of
I mean,
count 2.
But I've been a prosecutor before, and there were times where we made the arguments like, look, Judge, no. We're going to explain you why you can't go down all these other roads.
Okay.
But never on something like this.
Thank you, Your Honor. And I will address the eligibility for diversion a little bit later in the comments that I made before.
That is nice. She can get diversion, possibly. I doubt she'll get it, though.
I wanted just to highlight a few things that I thought were very significant to the court's determination. I thought it was significant that Dr. Roy Neely of the Vanderbilt University Medical Center from the Neuro ICU unit sent an unsolicited letter to the court. I received a copy of it and made it part of the 40 character letters that were filed with my sentencing memorandum. Not anything that I spoke to Dr. Neely about, not anything that I solicited. And I think from the letters that you've seen, by all accounts, RaDonda Vaught was an excellent, compassionate, caring nurse. She was obviously very well respected among the doctors, among her nursing peers.
Just like Dr. Husel.
The University Medical Center even trusted her to function as Ms. Kessinger had functioned in the role of a preceptor, training new employees. One thing that I wanted to highlight from Dr. Neely's letter, he found her to be a thoughtful and caring nurse. I'm reading from a passage of his letter. And what was notable to Dr. Neely was the consistent high level of attention he saw her provide to so many of the DUMC patients and their families when they worked together in the Neuro ICU. He found her to be very conscientious, that she cared for patients in a very competent way. And he emphasized that she was not, quote, an average nurse. And he expressed general concerns about penalizing nurses for medication errors and the chilling effect that would have on nurses reporting errors. Some of RaDonda Vaught's nursing colleagues, I think, had some very poignant things to say about RaDonda and her work at Vanderbilt. A nurse by the name of Alexandra Shiro, S-H-E-R-O, for the court reporter, wrote a very extensive letter. And just a few highlights from that. She expressed what an honor it was to work with RaDonda Vaught, how much she had learned from RaDonda Vaught, what a clear leader on the 6th floor RaDonda Vaught was among peers and providers, that she was the type of nurse, if anyone had any questions, concerns on the 6th floor, she was the go-to person. And the theme that you've heard from a lot of the witnesses this morning is the over and above and beyond that RaDonda Vaught would go to spend personal time with her patients. Ms. Shiro also noted what was going on at the hospital on December 26, 2017, the day that this happened. She characterized it as one of the busiest mornings that she had ever experienced. Even though it was the holidays, they were very full, had many ill patients according to Nurse Shiro, many of whom needed imaging, needed to be taken from the 6th floor down to the 1st floor. As you know from the proof in the case, Nurse Vaught was the health hall nurse, and she had an orientee with her that day. So there were a lot of things going on for Nurse Vaught in that role as a health hall nurse on that day. And it was interesting that Nurse Shiro talked about midazolam, talked about Versed, and also talked about becuronium, and that in her experience, the fact that the becuronium had to be reconstituted, and she put this in italics in her letter, was not a red flag to her, given the medications that they were constantly being bombarded with and how many medications needed to be reconstituted. And also, she noted what came out of the trial, that Vanderbilt University Medical Center had recently changed their pharmacy dispensing system. So the letters are clear from her peers that she was an excellent nurse, somebody that could be looked to. I also made an argument in the sentencing memorandum that in addition to her extraordinary acceptance of responsibility, that's my characterization, talking to the people, the doctors at Vanderbilt, when they were literally at bedside in Miss Murphy's room back on the 6th floor, figuratively scratching their heads, trying to figure out, well, what's going on with Charlene Murphy. Once RaDonda Vaught was handed that plastic bag that had the wrong medication in it, she walked right into Charlene Murphy's room and told those doctors exactly what the problem was. And what followed, she went to an office and put together a Veritas report. The court may remember that term from the trial. That was supposed to be a confidential report that nurses and providers were to put together, where they report anything that they see at the hospital that they feel is not exactly right. And RaDonda did that. And what followed from that was a series of interviews. And whether it was the Vanderbilt University Medical Center, risk management people, to the Tennessee Department of Health, to the Tennessee Bureau of Investigation, and the court heard that 2-hour interview that was played for the jury. I also talk about good works of RaDonda Vaught in my sentencing memorandum in her community. And those letters attest to the fact that she's an integral part of that community and gives of her time and is always the person in the area that's willing to help out any of her neighbors. I thought that was significant. I also briefed the issue of her work ethic, her family contribution, that I think are also strong mitigating circumstances. And I also briefed for the court why I believe that RaDonda Vaught poses really no risk of recidivism. I realized that she was charged with misdemeanor perjury in the General Sessions Court for Sumner County. I think the timing of it, Your Honor, is interesting, to say the least. The event allegedly occurred in August of 2020. There was no law enforcement attention made to that filling out of the ATF form 4473 until a year later. And it wasn't the local Sumner County Sheriff's Office or the Gallatin Police Department. It was the Tennessee Bureau of Investigation. And of course, the Tennessee Bureau of Investigation is the lead agency in this medication error case. So I think they were motivated to pick up the mantle and go up to Sumner County a year later, create this crime, which had not been sought to be vindicated by anybody, not the ATF, not any local law enforcement. And I think I can report to the court as an officer to the court, of the court, that Sumner County is not going to be prosecuting that case. We were in court on May the 4th, and they've indicated that that case will not be prosecuted. I did want to talk about her eligibility for judicial diversion. And there's sort of a lot of statutory twists that I'm going to try to walk the court through and give the court my understanding of why she is eligible on that impaired elder abuse, the Class C felony. She is indicted under a now repealed statute, Tennessee Code Annotated 71-6-119, impaired elder abuse. It was repealed and replaced with another statutory scheme in 2018. And I know the court is familiar with a statute 3911.112 that I think contains the answer to this question. 3911.112 deals with repealed or amended laws. And the relevant portion of 3911.112 is this. When a penal statute is repealed by a subsequent legislative act, the offense committed while the statute was in full force and effect shall be prosecuted under the statute in effect at the time of the commission of the offense. And that's exactly what happened in this court in the month of March. But here is the language that I think gives the court the authority to grant judicial diversion as to count one. Again, reading from the pertinent portion of 3911.112. Except as provided under the provisions of 4035.117, in the event the subsequent act provides for a lesser penalty, any punishment imposed shall be in accordance with the subsequent act. So when you take a look at the current plain text of 4035.313, that would be the 2019 replacement, which is found in the 2021 supplement. You sort of need a slide rule to get through this maze, but when you take a look at 4035.313 B1C, and this is the 2021 version, the 2021 copy part, is not seeking deferral of further proceedings, and then it gives the laundry list of what you cannot be eligible for judicial diversion for. And significantly, 71-6-119 is not in the 2021 or the post-2019 version of 4035.313. It specifically does not mention the old statute that RaDonda Vaught was indicted for by the Davidson County Grand Jury back in 2019. So it would be my insistence based on 3911.112 and a plain reading of the text of 4035.313, where the old statute is not mentioned, and there are also some ex post facto concerns as well. But the fact that 71-6-119, the old statute, was excluded from diversion eligibility in 2017.
200 people watching. Thank you for tuning in, guys.
Analysis when you apply 3911.112. And I know of, I think the court is to, my understanding, the court is to use the current 4035.313. And I know of no saving provision that was enacted to, at the time that 71-6-119 was repealed. I know that's a little hard to follow, but when you read 3911.112 with 4035.313 and apply that language at the end of 3911.112, where in the event the subsequent act provides for a lesser punishment, a lesser penalty, and that's what we have here. So I believe that she is eligible for judicial diversion using the version that's in effect right now of 4035.313.
4035.313 entirely eliminated from the list of ineligible offenses, vulnerable adult abuse or neglect?
Your Honor, there are replacement statutes that are within B1 4035.313 B1C, but they are not 71-6-119. So I think based on that, she would be eligible for judicial diversion. I would ask the court to seriously consider judicial diversion. And the court is correct, the electroplating factors that you refer to, which are the accused inability to correction, the circumstances of the offense, the accused criminal record. She has no prior criminal record at this point. The accused social history, the accused physical and mental health, the deterrence value to the accused as well as others. Those are the electroplating factors that the court will apply, not the unfortunate comments that she made at a very emotional time right after the conclusion of the trial. I know that the state has brought to the court's attention an aggravating factor.
Let me back up just 1 second. Talking about 71, 6, 117, and 119, were those offenses repealed or should they be codified?
Your Honor, I think they were repealed.
They were completely repealed and basically redefined?
That's my understanding. You know, the only other comment that I wanted to make is the state has brought to the court's attention what they characterize as an aggravating factor, and that would be the abuse of a position of private trust. It's not mentioned in the pre-sentence report. There's been no filing that identifies it. I think that to have an abuse of trust, there would need to be a higher mens rea than an accident. And I think in terms of how it relates to count 1, as she stood there on the first floor in the PET scan area, at that moment in time, she did not know that she had made that medication error. She only became aware of the medication error sometime later when she returned to the 6th floor, and her colleague, Ethan Gully, had handed her that plastic bag and told her, you didn't give her SED, you gave vecuronium. So, both in terms of a lack of fair notice and factually, I don't think that abuse of a position of private trust applied in this Squat's case.
Thank you. Any response from the state?
Yes, I guess I'll endeavor to navigate this issue. I think it explained it pretty well.
Cut the argument short, Judge. This is nonsense.
Interpretation, yeah.
This should have been written up in a motion.
The act, as originally charged, was recodified. And the recodified statute, 3915-508, which today is gross neglect of a vulnerable adult, is specifically precluded. So at the time in 2017 when this offense occurred, it was specifically precluded under the statute for which Ms. Vaught was indicted. Even as it stands today, she is still statutorily precluded from diversion under the new statute. So the state submits 3911-1112 does not apply because there is no void in the law. There was no lesser penalty. The current law, which was
Let's just get this over with, Judge.
Health and welfare statutes into the criminal code, just changed sections from the 39, 17.
I will say I'm very glad we have you because I would watch this on replay and I have no idea what any of this means.
Yeah, they're basically arguing she can't get diversion and that they want prison time for her, but they're arguing over when they're belting out the numbers, that's how they reference it. You know, that part of the Tennessee code.
Yeah, yeah.
But yeah, this should have been done. You know, usually, I mean, like in my experience in Ohio, if we're trying to argue things, you put it in motion as part of the sentencing memorandum, arguing what's applicable, what's not, and that should have been laid out in previous writing. Like in Ohio, if you come in and try to argue this in depth, the judge is going to cut you off and say this is a briefable issue, not a one for you to lay out like this.
Yeah.
Also, guys, I wanted to let you know, I thought we'd be good to go and we'd have a chance to talk, but I have a 1:15 hearing that I have to go to, so I'm going to be in the car ride for the last little bit of this. We'll still talk, just want everybody to know.
And we can always debrief later on a,
Sure,
a
we
different
could.
one if you want to.
Yeah, we could.
Without knowing
But I know a lot of
verbatim,
people
I
are here,
agree
so I
with
Yeah.
like to give the people what they want.
Oh, for sure.
Yeah, I don't know what your schedule looks like, Liz, coming up.
So that, I'll move on beyond that. Your Honor.
Pretty much during the week, Fridays are my bad day, but we can chat about whenever.
Okay, well, I mean, your kids like melatonin, don't they? Just give them some
Yeah.
tonight.
It'll be totally fine.
Neglect, gross neglect, they're going to adult from diversion.
You're saying, let's just, you're saying that
Thanks for covering this, by the way.
Oh, you're welcome.
availability of diversion would not be considered a lesser penalty than under 435.176. That's not what that means. Is that your position?
I don't think it is. I don't read it to be a lesser penalty. It's a referral of proceedings. It's not the penalty is still there whether it applies or not. It is a function, it's a legislative law.
A lesser outcome.
It is.
It's a more favorable outcome.
It certainly does, but diversion is a legislative largesse. The legislature decides who gets it, and they specifically said in 2017, and then again after 2018 when it was moved into the criminal code, that vulnerable, gross neglect of a vulnerable adult is not murder. And can I continue on?
Go ahead.
Finish my remarks. But I think I think it tells a lot. We've heard good faithful testimony about Ms. Vaught from her friends and people she's known for a while. But it's very concerning to the state that she did lie on a federal firearms form to get an assault rifle when she was under indictment. It's also very concerning to the state that before the jury even decided her fate, she was saying profanities on the news and accusing me personally.
Once again, this is why you shut up and don't talk.
And yet
That part's
she
bad.
gave an unsworn allocution today. She chose not to testify at the trial, which is her Fifth Amendment privilege.
That should automatic.
Obviously, she didn't want to be subject to cross-examination today as giving an allocution as to why, what lies did the state make in our case in chief.
Oh, now we're getting butthurt. Now we're getting butthurt.
They went to the media. She ran out of the courtroom.
Now we're getting
Now-
butthurt.
Yeah.
He should
now
be
they
stopped. Why didn't she take the stand? It's not your none. I'm sorry, your kid's sitting right. Oh, you got earmuffs on,
Oh,
right?
I have my headphones on. Yep.
Okay. None of your motherfucking business, why, bro, dog? That's not Fifth motherfucking Amendment.
And telling everybody the truth. But she goes
Come
out
on.
there and says,
He didn't like that he was getting dragged through the mud.
and then we're out to
Yeah,
dinner.
you're getting dragged through the mud by some nurse. Oh, if that scuffs you up that bad, dude, I don't know how you hack it in a courtroom.
An emotionally charged week.
She's gonna call him out.
At the end of that week, an individual who has been through that
She's gonna tell him to ice it down.
might say things that they probably shouldn't.
She talked about her professional composure, keeping herself composed. Her allocution, she made it sound like she can hold her emotions together, but she didn't.
At
And
work.
She could have walked out of the courtroom and respected the prosecution, respected the sanctity of this court, respected the sanctity of the judicial process and the criminal justice system, but she didn't. She instead tried to say that everybody's lying against me. And I'm a good person, and I'm sweet little RaDonda Vaught. And I didn't testify because I didn't want to be drawn through the mud, but I really maybe didn't want the jury to know that I lied on a federal firearms form and committed perjury just to get an assault rifle. Because she's portrayed herself in the media and with the witnesses here today that she is just as pure as the driven snow. But I don't think that someone that is truly as genuine as she wants the court to believe would just to get a gun, commit a federal offense, and then go out and curse on TV and blame people who are public servants for doing their job.
Yeah, he's really offended. Like, he feels very personally attacked.
Do you disagree with Mr. Stryance that the state of Tennessee has chosen not to pursue that offense? Pursue that charge in Sumner County?
Your Honor, courts, different jurisdictions do things for different reasons. His implication was that we somehow stirred the hornet's nest on him.
Yeah, he's a big mad, big sad right now.
Certainly testified that the incident had come through TBI. That's how TBI got involved. And then when it wound up on Ramona Smith's desk, she's like, I investigated this woman for a homicide.
Is he insulting the judge?
Do you disagree with Mr.
I don't know what he's
Stryance
doing
that
right
the
now.
state of
He's just
Tennessee
crying.
has chosen not to proceed with that charge?
I have not received any word from, I can certainly understand the retirement and the subsequent dismissal after a period of time with a misdemeanor. I can understand that. But it's
He should be
still-
cut off. This is
I have not
done.
received any verified confirmation, neither has the court, that this has actually been disposed of.
least she's not taking her glasses off.
But Your Honor, I mean, the ultimate
It's a
question
first.
is when does civil medical negligence become criminal? And in this case, it's when it results in a death where a jury decides that she fell below the standard of care and committed so many egregious acts and oversights during that process that somebody died. And we had two members of the healthcare community on the jury who found for that. We had an expert witness who testified about the facts of the case and what nurses are supposed to do. They're supposed to check the medicine. Even their own witness said she would have checked the medicine. At the end of the day, just check the medicine.
The trial was live streamed, yes.
She grabbed the right medicine. And I won't go any further with that, but we're talking about, she didn't even look at the medicine. There's no proof of that. That is completely egregious in this situation.
What's the state's recommendation on sentence? That you've just made the same argument you made to the jury, and they agreed with you. They agreed with you. So now tell me what does the state wish the court to do on
The
sentencing?
state wishes that the court, whatever sentence the court imposes and whatever words the court uses in pronouncing the sentence must promote respect.
The state wishes you would stop bullying me on the media.
Sanctity of her family and respect for the judicial system, this court, the criminal justice system, and the jury's verdict. Whatever that may be.
Make the mean nurses stop bullying us.
I'm asking you about the sentence. I mean, the sentence is what it is. The length of the sentence, the manner of service, and I understand the state's position on diversion. I understand that position. What's the state's recommendation on the length of sentence and applicability and propriety of an alternative sentence?
We are not seeking, we didn't file an enhancement factor. She does not have a record, so it would be between 3 to 6 years for the C felony and 1 to 2 for the E felony.
You argued an enhancement factor earlier. You're asking the court to enhance the sentence.
Ranging, enhancement as in within the range.
Okay.
Enhancement factor would be whether.
So you're arguing she's a standard offender.
She is a range 1 standard offender.
Okay.
Not felony.
And you've argued that at least one enhancement factor is applicable.
Yes, Your Honor.
And so do you have a recommendation or a position on the length of sentence as
The
to?
length between 3 to 6 years.
Mhm.
I think whatever the judge finds is fair between 3 to 6 years for this offense.
So you don't have any position about where?
We do not have a position
Okay.
on how long she is either incarcerated
Okay.
or placed on bail.
And you're not seeking consecutive sentencing?
We are not, Your Honor.
Okay. Are you advocating for any service of time in custody?
We are going to leave that entirely up to the court and your discretion and your wisdom.
I mean, I have statutory factors that I have to consider, obviously, but it's always helpful to have, we're in an adversarial proceeding, and I listen to both sides, I listen to arguments, and I weigh those arguments and apply them to the evidence before me, so. But you're saying the state doesn't take a position on probation?
The position that we have is she is nonverbal and deaf.
The man that's speaking is the prosecutor, so he's RaDonda Vaught's opponent in my non-legal speak.
Is concerned about.
All right. Thank you, General.
Yeah, he did say
You have a
3 to
response?
6 years.
Briefly on the eligibility for judicial diversion. Just by the terms of the replacement statutes, I don't think it's just a reconstructed statute because it is a Class B felony in its new iteration.
Sorry about the kids' show music. Coco Melon is it's life.
So he would be
It is Coco Melon, yes.
Totally fine, no worries.
served 71
I do like the fact the judge said, so what do you want me to do?
mentioned by the legislature in 4035, 313C, B1C, and it's not. And I would ask the court to apply the plain text of the current version of 4035, 313, and find to be eligible as a count one.
Thank you, Ms. Triance.
Can I refer just very briefly? on
Yes,
this?
ma'am.
I apologize, Your Honor, I had it pulled up and I lost my place. I'm almost there.
God, I don't know. Why is there not a, this is ridiculous.
Your Honor,
You know, if there happens to be somebody from Tennessee who can ever tell me this is normal,
the reason that these
you guys need to fix this mess.
offenses
Hopefully you guys can hear me all right.
codify them in the criminal code.
You're a little bit loud, but we can hear you.
The 71 section.
This is just nonsense, complete nonsense.
And the District Attorney General's Conference made a big push in 2017, 2018, 2019 to have these laws moved over because of the creation of the Vulnerable Adult Protective Investigative Team and these acts to try and promote stopping abuse, neglect, misappropriation, financial exploitation, sexual abuse of vulnerable and elderly adults. So the big movement came to codify these within the criminal code. I disagree with Mr. Strians. If you look, and this is specific to 4035-313 now, if you look at the statute for 4035-313 back at the time of this offense, which was the charge that in the 71s that she was convicted of, it is specific in that statute that it is.
Can you guys hear me okay? Let me know, please.
If you look at 4035-313,
We can hear you okay. You're a tiny bit loud.
specific as to the same part of the statute, 3915-508, which says offense of aggravated neglect of elderly or vulnerable adult. Talks about the caregiver commits the offense of aggravated neglect of an elderly or vulnerable adult who commits neglect, results in serious physical harm. That is the same language. Now, that still keeps it at a Class C felony. The B felony results in serious bodily injury. That's what bumps it up, that classification. But serious physical harm, that's the same type of harm that the state had to prove in order to find her guilty.
I agree with you that it looks the same.
Yes, Your Honor.
It's kind of similar.
Yes, Your Honor.
And maybe the intent is that we're going to take this crime out of this section and we're going to put it in this section. My question is, and my question before was, has the statute been rewritten? Has the offense been redefined in any way? I'm hearing Mr. Striant say that at least part of it has been elevated in terms of sentencing. So it's not entirely true from what, unless you disagree, that it was just picked up and moved from one section to another. It was literally repealed and rewritten. So am I allowed to sit here in this proceeding and see if I can figure out what the intent of the legislature was? I can't do that, can I? I have to look at the statute.
Yes, Your Honor, but I think it speaks volumes.
If it was repealed and replaced, it's been repealed and replaced, not modified.
These crimes were moved to the criminal code.
But I can't consider that. I have to look at the statute.
Yes, Your Honor.
So guys, they're not trying to add the charges to get her charged with perjury. They're pointing out she committed a crime to show why she's not amenable to probation and she should get prison.
Mr. Jackson said, this particular offense was
Gotcha. Yeah, that's helpful clarification. Thank you.
of an elder or of a vulnerable adult is still precluded even today from obtaining 4035-313. That is the intent of the legislature here, Your Honor, because that type of crime hasn't changed. It's just been moved over to the criminal code and recodified.
But there has to be more than it being just that type of crime. It's more than that. It has to be because this offense, 716119, does not exist anymore.
It does not, Your Honor.
So 716119 no longer appears in 4035-313. So what gives me the authority to ignore the plain language of 4035-313 and to include a crime that does not exist anymore in the list of crimes for which diversion is no longer an option?
I want them to stop the prosecute because they're so annoying, but I don't at the same time because I want them to make the judge more angry so she gives a more lenient sentence.
Had she been prosecuted under that time when this specific crime was listed in 4035-313. Obviously, the legislation has changed. It's been updated to reflect the new laws.
This case has been pretty huge in nursing, amongst the nursing community.
What's specific is that the court has to
me why, my question is, tell me how I can consider that. Tell me how I can look beyond the language of 4035-313 that's applicable today. And if anyone else has any, I'm happy to hear from anyone from the state on this, because I don't know, I'm hearing about, and I understand that the legislature does things and makes decisions and rewrites statutes all the time. Maybe it was an oversight. If it was an oversight, I can't call it an oversight, I've got to look at the language of the statute.
Your Honor, do you have a copy of the 4035 that was effective from July the 1st, 2017 to June the 30th of 2018? If I may,
I do.
just make sure that we're comparing apples and apples.
You're saying the copy that was effective,
At that time specifically,
okay, hang on.
Amanda, I think criminally charging a mistake that was a true mistake, no matter how epic and big the mistake was, is going to harm patient safety going forward because no one else will come forward.
335-313,
Is my synopsis.
effective until January 1, 2020, is that what you have here?
2017.
Okay. And it includes 716119, I see that, and the statute, the section that is applicable until 2020 also includes 716117.
Yes, sir.
Okay?
And just to let the court know.
Yeah, I understand that at one point it was included.
Yes, Your
But
Honor.
my question is, now it's not included.
But
So,
specifically, the welfare code section 716119, is not included, but because it has been converted over to the criminal code, and just to let the court know, if you look in the code now, if you look at 4035-313.
And it won't make nurses double check their work more. Like that is not how safety things in healthcare usually work. If you're making someone more scared, they're just going to want to cover it up more. Most of these mistakes are made because of system failures that allowed them to be made. And so if you don't report them, we never find out what the system error was, so we can't fix it moving forward. And that's the super frustrating thing about this.
Exactly where 716117 and 119 is listed in that statute.
Exactly, Melinda. And if nurses are worried about going to jail when they make mistakes, they're not going to report it. So the mistakes are going to keep happening and keep harming more people.
Is the aggravated neglect of an adult. So I think there's a problem here with the way it's written. I certainly agree with the court here. But
I mean, I can't correct that, can I?
no, Your Honor, but I think looking at the intent here of what the legislature did by recodifying into the criminal code, putting the exact same type of charge, gross neglect, aggravated neglect of a vulnerable elder adult.
Guys, I know the word to describe this. This is nonsense.
4035-313, because the law has just been modified or updated to be in the criminal code. I don't know that the legislature would have added 716117 or 716119 just for the simple fact that that's not.
They wanted to, they saw that the Johnny Depp Amber Heard trial was getting some news time, and they were like, watch me.
It is if you
Just
committed
watch.
an offense when that was the statute in effect,
Yes, Your Honor.
as we did here.
Yes, Your Honor, but I think the court can take consideration of the fact that it was enumerated in 4035-313
Yes, but
at the time, and that's the time that she committed the offense.
Your your audio is really choppy.
Held under as for sentencing, but I think the legislature.
It's my stream now.
This particular statute in the 2021-2022 books, just because that's not under, we don't act under the welfare law anymore. It's specific to the criminal code. So I don't think you can just negate the fact that the statute has changed without looking at the language and the meaning.
Must have thought, well, the case isn't until Monday. We'll take up the airtime.
The intent of the legislature here is
Exactly. They're like, let's see what kind of a performance we can get going here. Your audio is better now, by the way.
you cannot financially exploit. If you do, you are not eligible for 4035.
So just to be clear, your argument as to the reason that 3911-112 that deals with repealed or amended laws, the reason that would not provide relief in this instance with respect to diversion is because The offense is similar, and the legislative intent was that it just be moved to a different section.
That is exactly what happened, Your Honor, and that was the big push by the District Attorney General's conference to codify these offenses within the criminal code, and the court can see that based upon the 39-15-502.
All medications were being overridden where she was working at the moment because the computer system was not talking to the medication dispenser. So she overrode it, pulled the wrong med out, and gave the wrong med.
Okay. All right.
But the unit was instructed to override meds because it wasn't working the way it
Take a
should.
recess. I'm going to review the evidence that's been presented, review my notes from the trial, review the case law and the legal arguments that have been presented, and then we'll come back.
I think that's critical to point out. She did not break any hospital policy,
That decision will
but
probably,
she did what she did.
I'm going to estimate that it's going to be probably 1 o'clock before that happens.
Correct.
So, if you want to plan to be back here by then, I'll have a decision.
All rise. Court's in recess.
How long did you say she was taking a break for?
An hour and 20 minutes. So she'll be back. She said 1 o'clock. I think Tennessee is in Central Time.
Oh, so we're coming back in an hour and 20 minutes. Okay, well,
Yeah.
on good news, that kind of takes care of some things I was going to have an issue with, but with my situation, super chat from VO216, $20. Thank you very much. Greatly appreciate it.
Yeah, people are saying Tennessee has 2 time zones. Yeah, I think it's probably in an hour and 20 minutes.
Yeah, well, that's
Yeah.
yeah. Because when they said it started at 9 a.m. Central, I got on it and it started at that time. So I think they're Central Time.
So are you going to come back later? Because we could always.
Yeah. So guys,
okay.
Here's the deal. I've got probably about 15 minutes or so left, so I need to go to court. I thought 2.5 hours would be more than enough. Apparently, I was wrong. So we'll come back. And so at 2 o'clock Eastern time, sounds like we start back up. And if I'm back in Delaware court earlier, I will fire this back up, and we will talk. Liz, you're more than welcome to come back. I can invite you back in if you want. I know you're busy getting ready today, so don't want to take too much of your time.
Cool. I'll hop back on probably when they come back. That sounds good.
Sure.
Yeah.
And if you just want to, I was going to answer some of the questions I started.
Oh, yeah, for sure. Yeah, I can hang around for a minute and answer some.
Okay. Yeah. So, guys, I know some people were questions about, like, how did she not know what happened to the machine? And, like, they were told, override the machine, get the medicine out, and do your thing. That was, she completely followed protocols, followed all rules. She's not been charged of doing anything wrong in that regard. That's entirely normal. For the doctor usually, because there are always computer problems. So, overriding the machines, yeah, they're meant to stop you, but when the machines aren't working, you have to, where you have to tell them not to do something, but you have to do it. The machine tells you.
Yeah, and your audio's still, it's having some sadness. It's chopping in and out. All right, this is my stream now. But if you guys have any questions, you can leave them in the chat and I'll answer them for a couple minutes. And then we'll pop back later. But what he was, and I have a human, of course.
Am I better now, guys?
Yes, that's better.
Okay. Yeah. So people are asking about, like, why was the machines? What's the deal? Doing as instructed, and they were having problems with machines anyway. So, to follow the machine's going to do what you do. But you have to dispense the medication. Wrong.
It's mad at you again. I wish I had better news for you.
I'm sorry.
She is not in jail right now. She has not been in jail this whole time.
She's been out. I'm just gonna go through a couple real quick and we'll cover them. So, guys, I have a court hearing at
So Sean has to go to a court hearing. We can't hear him right now because he's driving under a bridge. But I can hang out for a minute and take over his stream from him without his permission. If you have any questions, I can answer them. So the potential punishment was 3 to, I think, 6 years is what the prosecution was asking for today, is what they wanted. But she could get, I think, as minimum, I don't even know. I know nothing about the law. I'm a nurse practitioner, so I literally learned what I've learned on LawTube for the case with the Amber Heard trial because I snuck into Legal Bites channel. Corn Pop, I don't know. I think we'll probably leave the live stream up. I wonder if he has like a away message so that it can all be in one stream. I don't know. Hopefully, let me ask him in the chat. Me to leave this stream up, or are we starting a new one when court returns? Okay, I'll let you know what he says. I just asked him in the back end of things. But yes, welcome to my chat. I'm just slowly taking over LawTube. Let me see. Are we staying live? Okay, we got that one. How will this affect the nursing community? So if the the big thing here and the struggle that a lot of nurses have with this is normally when if you make an error and you are like legitimately just like, oh my gosh, an oops happened here. Usually it's reported to the Department of Health, who controls your nursing license. They usually have a hearing themselves, which they did for RaDonda, and they decided that she was fine. They said, hey, you actually, we're not going to do anything with this. She had quit her job. She was fired from the hospital and she had taken a non-clinical job. So a job that wasn't necessarily dealing with directly caring for patients. And then when all of this blew up, when a whistleblower told the Center for Medicaid Services, who pays the hospital, so the hospital really wants them to keep getting money, they said, hey, we won't pay you anymore unless you show us that you fixed whatever caused this error to occur. Also, why didn't you tell us about this? Because the state was like, you have to tell us when you accidentally kill people. That's the general rule. And Vanderbilt had not done that. They had the healthcare provider write on the death certificate that it was of natural causes, even though it's quite obvious that this was probably related to the medical error. So I don't even remember, where was I going with that story? I have ADHD. I have ADD. It struggles. Oh, so how it affects the nursing community. So usually when something like that happens, you feel like you can report things, which she did, because you won't be punished for it. If anything, your nursing license will be taken away and you will be civilly tried and given a civil punishment, and pay a fine or whatever, but usually you're not going to jail. And so if nurses feel like they're going to go to jail, you are not going to ever report those errors. You're going to try to cover them up, which is going to cause more people to die. And the systems that failed will not be identified. So more people will die. The hospital is not being charged because you can't charge hospitals. And since the hospital was able to change, they came up 10 months later when it was all came to light, because they changed nothing. After all this happened, they did an internal incident report. So the hospital knew what happened, but they changed nothing about their policies that let this happen. And there were a lot of hospital policies that were not in place. It just didn't exist at the time that let this error happen. But the hospital did nothing about it until they were threatened to have all of their funding cut. And then they said, oh, look, here's our nice presentation of here's what we're going to change. And you cannot sue a hospital. So all they literally got was, oh, thanks for changing this. And then the hospital, in my opinion, in order to make the attention away from them, pivoted, and someone got in the ear of the DA's office and said, hey, we should probably criminally charge RaDonda for this. Interestingly enough, the person who is the DA like is associated with the hospital, like works at Vanderbilt. And even though Vanderbilt, the hospital, and the medical center are not the same thing, it's obviously a very similar institution. So in my mind, I'm like, well, they probably said, hey, could you just criminally charge her and get the public's attention away from this? And then all the nurses were super mad because they said, if you criminally charge us, we're never going to, like, that's not going to incentivize people to make any change. So that's the issue there. Liz, can we go to your channel? I don't have a live stream set up on mine right now. So I'll just take over this one. It's fine. I'm going to do a video on my channel updating about this. So we'll do it there. I'll probably do a live stream on mine about the topic probably tonight. So if you want to follow my channel, that's where I do that. I talk about all healthcare things. I have a lot of opinions and I share them. That is Slap Murphy said that's a huge error, though. Can't it be any larger? A huge medical error. It's a huge error for sure. And I'm not even necessarily against the fact that they didn't, like, they took her license away, because that is a huge error. She made some big oopsies, but she immediately admitted it, which is huge. And errors like this happen all the time. I have seen many of them. I worked as a nurse bedside for 6 years, and then I was a nurse practitioner in primary care for 3. And I have seen epic mistakes that lead to horrible patient outcomes. And the hospital just pays the family and they pay the family because the family is not going to have the money to sue, they figure. And so the family, who has now lost a member of their family, they're like, well, I can't afford to sue, but you're going to offer me money. So they take the huge settlement, but in with the settlement, the hospital says you can never talk about this. So that's why the public never hears about things like this. This is a huge med error, but huge med errors happen absolutely all the time, and the hospitals just pay to cover it up. I cannot tell you how many times I have seen patients die and the hospital just pays the family, and nothing, it never gets anywhere. It never gets on the news. And these are like big oopsies, like big. Vanderbilt, some people were showing different things of Vanderbilt, of, you know, how many times people have had the wrong leg chopped off, they've removed the wrong kidney. And all of these physicians still work at the hospital who have literally chopped off the wrong feet and legs of people. But the hospital just, you know, here's a little bit of money, never mention this ever again, and off we go. This happens all the time in healthcare, and it needs to be talked about more. Corn Pop, why do you think this was pursued criminally? I think it was because of that. That they were trying to get the attention off of her. More people will die or more will be covered up. So Slap Murphy said, will more people die or more will be covered up? I think if we criminally prosecute, more people will die, because the way in healthcare, usually how it works is, so if I make a mistake and I, let's say, so a case from my own life, I one time pulled, a lot of times in emergencies, you go to the computer and you type in the medicine. Normally the medicine you pull, the medicine machine, it connects to the computer. So it knows what has been ordered for your patient. And when you type in your patient's name, a list shows up and it says, hey, these are the medicines you can choose from. In an emergency where a new situation shows up, the medicines have not been approved by anyone. They have not even been ordered yet. It was someone literally saying, hey, go and grab me 2 milligrams of this medicine. So I have been in an emergency before where someone said, hey, go grab me 2 milligrams of this medicine. I went to the computer. I was told a generic name. And so a generic name is Tylenol or acetaminophen. And the brand name would be Tylenol. I was told the brand name and I typed in the wrong generic name because it sounded very similar. I pulled the med. By the time I got to the bedside, it was caught. The error was caught. The patient wasn't given the medicine. However, you had an error there because I had to override it. And that's what RaDonda had to do here, is she had to override it, which led to a lot of systems issues. I wrote an incident report about that. And at my, because of that, I was never punished. They never said, hey, they just said, hey, make sure you're double checking this. But it was viewed as a systems problem that I was allowed to make that error, because we wrote an incident report and the hospital looked into it. And we actually had a policy change where if you were saying a verbal order, they were no longer allowed to say the brand name, because the medicine machine only spoke in generic names. So you had to verbally order the generic name. So you would have to say, I need 500 milligrams of acetaminophen. If you said a 500 of Tylenol, you would have to get clarification. Please give me the general name. And that was an institution-wide change because of the incident report that I was involved in. I reported it because I was not fearful of getting in trouble. Obviously, it didn't end with a patient death, but I've seen many that have. And the nurses reported those errors because they, or the healthcare provider, the nurse practitioners, the physicians, they report the errors because they know that in the culture of healthcare, if you meant no harm, if this was a real mistake and you report it, you write the incident report and you see, how can we change this in the future so that this never happens again? We're not going to punish you. We're going to punish the system because it let this mistake happen. And if you criminally prosecute someone for a mistake that they made, no matter how big it is, it's going to happen again, because I promise the next time it happens, they're not going to say anything. They're just going to try to cover it up and more people will die. Thank you for coming to my TED Talk. I feel like LawTube is very like succinct. So I apologize all of you who are here from LawTube, but I am not succinct. But thanks for being here. Big Chunga said, this is going to hurt recruiting efforts. The US already has a massive shortage of nurses, and once they get wind of their institution, throw them under the bus. It will help retention. If you go on right now to, so Vanderbilt, she worked at Vanderbilt Hospital. Vanderbilt cannot hire nurses to, like, they literally cannot. They went from offering, I think, $5,000 bonus, and then they went to a $10,000 bonus to get nurses to work there. And nurses are so pissed that they are so angry because of all of this that they won't go work there. And it's spread like wildfire. They're now offering tuition reimbursement. They're offering all these other things. And literally everyone, you know, I have seen lots of things on the nurse internet of, you know, getting recruiters emailing them or texting them and being like, hey, I have a travel assignment for you. And they're like, where is it? Like, all the benefits sound great. And they're like, oh, it's at Vanderbilt. And they're like, never, like, I'll never go there. So yeah, Vanderbilt is getting roasted and they can't hire anyone, which also harms patients because obviously they need to hire people because they don't have enough nurses to take care of their patients. But no one will work there because they're like, big middle finger to you, friend. I don't know if we're allowed to swear here, so we won't. We'll try to keep this chat monetized for him. I don't know why they used, Corn Pop said, I don't know why they used Versed, not midazolam. Yeah, so midazolam, so that's the issue with the generic name versus the trade name. She had to go, midazolam is the generic name for Versed. Versed is a medicine that chills you out and it gives you, that's the one they give you when you go to the OR and like you go into La La Land and you don't really remember anything. You're awake, but like you're sedated and you're a lot more chill. That's what she was supposed to give to a patient who was having a lot of anxiety in preparation for a PET scan. She went into the computer and because she heard Versed, she went and typed VE and vecuronium popped up because the computer didn't recognize Versed, the beginning of Versed. It just saw VE because it was a generic versus a brand name. So she pulled out the vecuronium, it let her, and she gave that. And vecuronium is a paralytic that you can't, that it causes your diaphragm, all your muscles to be like your big muscles to be paralyzed. So your diaphragm would stop moving. And that is how the patient passed away. If you want to give vecuronium, you need to be intubated and have something else breathing for you. And she didn't. So it was a horrible way to pass away. But that is the error that happened, was it was a confusion about the name. I have not heard, oh good, everyone else is saying that LawTube rambles. That's great. Literally my dive into LawTube was this case because I was so angry that I was like, I need to talk about this. So I went onto the Googles and I found Alita and I've watched Emily Baker for a long time. But I was like trying to learn legal things so that I could present this case on my channel and make an educated video about it. And then I got introduced to all of this and now the Johnny Depp thing. And now I'm like, maybe I need to go to law school, apparently. But I'm glad that other people are also long-winded. I don't think I'd describe LawTube as succinct. Perfect. Excellent. What was her sentence? They haven't sentenced her yet. They've been arguing so far. So I have no idea what's going on. Like I said, I'm not a lawyer. But it seems like the prosecution and that, which is the anti-RaDonda. So I just call them the enemy. That's probably not how you're supposed to refer to them as here, but the enemy and the defense, RaDonda, their lawyers have been fighting because they're trying to change something. I don't know. That's why Sean's here. Or when he comes back, we'll ask him because I don't know what's happening. I was under the assumption that we would show up and they would just be like, hey, this is the sentence that she's been given. But they've been arguing. The enemy is very petty. The judge, in my mind, has already made up her mind. And seems much less into giving like the type of sentence that the enemy wants her to get. So Matthew Beer says, join me as a legal nurse consultant. I need to look into that more and see what that would entail. I don't know if anyone would ever want to hire me because I feel like I would almost always be on the side of the nurse. I'd be like, no, that's totally fine that they did that. Our healthcare system needs to burn to the ground and be rebuilt. So it's the system's fault. I don't know if anyone would want to hire me with that. Let us see. I didn't know. I don't know how I didn't know you had a channel until just now. I just subbed. Why, thank you. I do have a channel. I talk about more healthcare things, but also like current events that kind of tie into healthcare. So anything like that. What do you think about the Corn Pop said? What do you think about the issue that she had to reconstitute the VEC and midazolam is never reconstituted? I think that is the most puzzling part. So that to me, I don't know why people have focused on that a lot. And to me, that's not a big issue because she had given Versed 6 times, I think, in her life. Midazolam, she'd given that 6 times. That's not like a terribly large amount of time considering the number of medicines you give. And pharmacy changes how meds are given all the time. So I think in her mind, she probably thought either she was like, oh, maybe maybe they changed the formulation on this and now I have to reconstitute it because the pharmacy day to day, you go in and you pull different meds. And yesterday this looked totally different. The packaging was different. The color was different. Usually it's not the case that something was not reconstituted, but now it is. But I can very easily see myself going into a situation and be like, oh, I guess I have to reconstitute it now because the hospital's too cheap to buy the same stuff they did last week. So now I have to reconstitute this. I have never worked in an ICU, so I have never given vecuronium. I've given Versed a bunch, but I can very easily see how she made the jump to, I guess I have to reconstitute this today because meds that are given change what they look like absolutely constantly. So that to me has never been a huge issue because that's what I would assume, but other people take a lot of issue with that. I also don't think 6 times is like the most in the entire world to have given a medicine. But that's just me. If it was something that you give that she gave every day, then yeah, I'd be like, what is this? Like, why do I have to reconstitute it? But Alpha Fox Adam said when she overrode the dispenser, she heightened her duty. She failed to check. She also failed to realize the brand generic name. She was the ultimate. Yeah, she was the cause of death in the patient. And she's owned up to that and she's admitted it. No one's saying she didn't make a mistake, but mistakes like this happen all the time. And if we criminally prosecuted every single person who's made a medication error that caused death, because there's I forget the statistics now. I had them in my video. It's in the tens of thousands of mistakes that are reported med errors that lead to patient death a year. So are we going to go prosecute all those nurses? Because I bet most of those have also led to many mistakes that compounded to make these horrible outcomes, but they're never going to go anywhere because now no one's going to say anything. Tens of thousands every year. Hers is getting highlighted because I think the hospital's kind of throwing around, got some people to make some reports, but tens of thousands of medical errors where people make oopsie, this is terrible, that we can learn from, but we're never going to learn from them because we're never going to report them again. Ruth, what specialty did you work as a bedside nurse? Med surge with GI, liver, kidney stuff, and then pediatric cardiology. For many years. The hospital should report their employees when they make an honest mistake. I don't know how these chats are appearing on the screen unless Sean is still on the back end. If you are, hello, thanks for letting me take over your channel. What did she Amanda Davis Bates said, did she ask anyone about this? I don't think so she was precepting someone. I don't think she asked anybody about the, when she pulled the medicine and it was wrong, or it was the different one. I don't think she asked about it having to be reconstituted. But at the same time, if I thought like, oh, they just changed it and I need to reconstitute, I don't know if I would ask. I mean, I would definitely I would hope I would double check and do all of that. But if she thought, if I'm just putting myself, I don't know if this is actually her line of thinking. If I thought, oh, I just need to reconstitute that because the pharmacy changed it up, I don't know if I would go in. If no one was around, I might be like, oh, this is weird, but I can't say that I don't know if I would hold that against her that she didn't do that. You know what I mean? And Melinda, no, we wouldn't have any nurses if we just criminally charged the tens of thousands of people that have accidentally caused a fatal med error, because everyone would be like, no. Alpha Fox Adam, what percent of med errors go unreported? I would probably say 75% go unreported. Reporting a med error is time consuming. And this is just going to sound bad. So like nurses, you just don't have any time. You have way too many patients. You're already stretched so thin. Usually reporting a med error like that, it's going to take you more time to document it. The forms are super long. You're going to get called in. They're going to ask you more questions about it. I would say 75% of the time when I have seen or heard of a med error, no one does anything. They don't report it because it takes too long and they're already stressed. So yeah. It's not great. So safe staffing for nurses is very important because it's not like nurses are out there trying to harm people, but if you are stretched so thin that you're just trying to survive the day, yikes. And this is a good point. Slap Mercy. Or Sam said, nurses aren't the only ones making errors in hospitals. Nurses catch doctors' med errors all the time. Absolutely. So I'm not trying to make this sound like, oh, we're out here just like screwing up all the time. Everyone in the hospital makes a crap ton of errors. Everyone in healthcare makes a lot of errors. I have caught endless amounts of mistakes, because the entire way we do things, we throw resident physicians into situations in the middle of the night. We're like, hey, you graduate med school. You don't know anything when you graduate from med school, in case you didn't know that. You're a generalist, but you know absolutely nothing about the floor. Like, nothing when you graduate from med school of real life medicine. They throw these residents on the floor. They say, you need to work 80 hours a week. You're new to this city that you just moved to. You're going to be working at night, and you're going to be doing it by yourself. And if you screw up in the morning, I'm going to ream you in front of all your friends. Everyone else that's in this room, I'm going to ream you in front of them for not knowing how to do the job that you were literally never trained for. So that is the residents. So those are the people writing the orders, right? And they still work crazy hours. And so that's kind of the environment that healthcare has put forward of learning, is learn as you go. Yes. Learn as you go. So the thing in healthcare is called see one, do one, teach one. So it's kind of a train wreck, and a lot of mistakes are made. We'll just say that. Not a lot of them are reported. So to criminalize the people who did report, it's not a good look. It's just not a good look. Yeah, there's a reason why fake it till you make it. Sean muted my mic. I unmuted it. That might mean he wants me to go. So we can go, and then I'll be back later at 2. Because he probably wants this dressed. I think we're going to leave this stream open and everyone just come back at 2. Does that sound good? I've made the executive decision. I haven't heard from him. Parallax said off topic to RaDonda, but do you follow Christopher Dunch at all? I don't think so, but I also have a terrible memory and I need to see things before I remember them. So I might, but that doesn't sound right. Pretty sure I heard in the trial, but I forgot her assignment was called. She wasn't the patient throughout her stay. No, so RaDonda was not the patient's primary nurse. The patient was going down to a PET scan. The patient's primary nurse was too busy and couldn't go with her. So usually if your patient needs something, while she was, and she got pulled out of the middle of a different task to do it. So the whole situation was probably a little bit disorienting. I'm on, Sean says, I'm in cell coverage hell. Please let everyone know we will be back at 2. Asking him if it's the same stream or a different one Amanda, I'm enjoying the chat too. I'm so hungry. And if I don't eat, I don't know how LawTube people do this where they like with the Johnny Depp trial, they just go all day and they don't eat. And I'm like, I need to be fed every few hours or I get real cranky. So go well. Let me see. New stream. I'll start up. Okay, so he's going to start a new stream. Okay, so everybody, we will reconvene at 2 in a new stream. I'm going to end this stream. I'm going to let us all go. Okay, so everybody come back at 2.